जो हमने सारा कर
Hello, check 1 2 3 4 sound check.
Just give it for the chat is there.
इसमें तो
Just see
Yes. But before my friend starts, there's a slight tweak in the sequence. Mr. Jaideep Gupta and Mr. Bhushan will be going immediately after Mr. Patwari.
So, my lord, I have been given 15 minutes. I will stay within that time. My lord, I have
You
made,
got an hour more. Otherwise, if you would have concluded the other day, you would have got only 2 hours. You are getting 2.5 hours.
correct. So, my lord, just to facilitate and save time, I have put in writing what I had argued on that day. It is just 5 pages. I have given it to your lordships, my lord. If your lordship will see page 1 of what I have handed over, my lord, the written submission. Page 1, I need not read or repeat. I had already told your lordships that Delhi, the promotees,
Situation is reversed.
yes, is reverse. I have recapitulated that in page 1, my lord. I need not read it. Your lordship would see it, my lord. That is the position in Delhi. Now, on weightage, the argument of weightage for the promotees, which was made, also I had submitted, my lord, and that is the second point at page 2, that 3 avenues of accelerated promotion have already been now opened for them. And I have at page 2 given as A is the first avenue, that 25% quota of in district judges by way of LCD. And at the extract is of your lordship's 2025 AIJA judgment, my lord, where your lordships have recognized this, that purpose was behind providing a special quota is to enable meritorious judicial officers to get accelerated promotion. Then at page point B, I have said that this your lordships have also now opened from junior to senior level. This is the second accelerated advantage. And at C, third, your lordships have now also made them eligible to compete for direct recruitment. This is the third. And and therefore, my lord, the submission is that no further weightage, perhaps your lordship may consider granting, my lord. And weightage, I have said at D, has been disapproved in the 2002 judgment, that para I have quoted. Now, my lord, what I wish to spend some 10 minutes is on my point number 2, roster for maintaining seniority, because in my submission, that may be an acceptable proposition. The doubt which your lordship expressed that because direct recruitment can get late, people join later, and then they can't get those earlier slots. I have tried to make some suggestion, my lord, for your lordship's consideration. Can I just take your lordship through these 4-5 points, this one page, my lord? Now, roster for maintaining seniority. It is submitted that the contention that the roster system introduced pursuant to the 2002 judgment has failed is incorrect, as the roster system has never been given a fair chance to operate due to lack of year-wise recruitment across all streams, which is an essential requirement for its full and effective implementation. The 2002 judgment in paras 2930 laid down the roster as a post-based system designed to secure fairness, transparency, parity between promotees, LDC, and direct recruits. When recruitment is done regularly and on time, the roster system helps all 3 streams to move forward with a proportionate representation in every block of 4 vacancies and also prevents disputes of seniority. So if properly implemented, it is 2-1-1. So in every block of 4, we will have all 3 categories. Now, Malik Mazhar becomes important because your lordships have laid down a yearly schedule. Your lordships have said calculate vacancies, advertise by March, complete the process by September, have the select list ready, and by October 31st, all 3 streams should be appointed. That is the schedule which your lordships have laid down in Malik Mazhar, my lord. Malik Mazhar is also on your lordship's compilation. If your lordship, it is in volume 5A and page number is 483. If your lordship wants to note, I'm not going to read it. That schedule is there. It was read earlier. Then if your lordship will come to point 3I, the applicant submit that vacancies for each stream, that is promotion, LDCE, and direct recruitment, should be calculated with reference to the total sanction strength of the cadre to ensure proportionate representation and continuity. Once appointments from all 3 streams are made for a given recruitment year, seniority must be assigned strictly in accordance with the order of slots under the roster on a yearly basis. The approach implemented on a yearly basis would balance inter-C seniority and maintain the 50-25-25 ratio in a block of 4 vacancies. This is judicially accepted, my lord. That judgment I have reproduced at serial number 6 of the same point in that state of Punjab's case, where I have extracted that para, where in fact the court said, because it's a yearly recruitment, operate the roster. Now, my lord, the other 2 points are the doubts. What happens when one process gets delayed? And then comes the heartburning, because that man is coming a year or 2 later and then wants to get that earlier slot. I've tried to say something about it, my lord, for your lordship's consideration. Now, I'll read 4 and 5. Experience across state shows that promotion under the 50% promotee quota are generally made promptly, while LDCE and direct recruitment appointees are often delayed due to litigation or administrative delays. In such cases, this court has consistently held appointment should relate back to the year of vacancy. Now, next, if each recruitment process is completed within the recruitment year and all streams join, then there would be no cause for any heartburn by operation of the roster. This court can mandate that process to be completed within the year or at any rate within the next year before that year's select list is finalized to minimize the cause of heartburn. If I can pause here. This is important. If you are completing the process as per Malik Mazhar and by 31st October, all 3 streams are joining, then they will be fitted into the roster, no problem. My submission is, my lord, perhaps your lordship may consider mandating, because the next year's select list at the earliest will be available only by October of that year. That is the mandate, by September of that year. That is the mandate of Malik Mazhar. If your lordships can provide a safeguard that even if there is delay, it should not go beyond the next year, then also, my lord, there will be no heartburn. However, if there is more delay, my lord, then what is stated subsequently is then to maintain the seniority and maintain parity, they must get the earlier slot. That is what I have submitted, my lord, and there is no escape from that if we are to go by the roster then, because then that is the only way you will be able to give a proportionate representation to everybody. So if I can just read this 5, my lord. In case recruitment process is completed within the recruitment year and all streams join, then there would be no cause for any heartburn by operation of the roster. This court can mandate the process to be completed within the year or at any rate within the next year before that year's select list is finalized to minimize any cause for heartburn. However, if due to certain circumstances, there is a delay in recruitment and the direct recruits of a particular recruitment year are not able to join within the recruitment year during which the vacancies had arisen, then the date of appointment joining should not be a relevant factor for determining seniority of direct recruits. It would suffice if action has been initiated for direct recruit vacancies within the recruitment years in which the vacancies had become available. This is so because delay in administrative action could not deprive an individual of his due seniority. Any such initiation of action for recruitment within the year would be sufficient to assign seniority to the direct recruit in terms of rotation of quota principle so as to arrange them within the promotee's vacancies. If the process of recruitment has been initiated during the year itself, then even if the selected candidates are appointed or join in subsequent year, the selected candidates would be entitled to seniority. Now, this judgment I have quoted, but I must point out immediately here, in this judgment, the fact was that all 3 streams joined in the same year, 2007. And therefore, what this court says, para 67, the court has, however, taken the view that date of joining is not relevant. Para 67, officers belonging to different streams have to be confident that they will be recruited under their quota and get seniority as per quota and roster. In the event seniority is to be fixed with date of joining of particular stream, it would lead to uncertainty and making seniority dependent on administrative authorities, which is neither in the interest of service nor serves the cause of justice. We thus conclude that roster is fully applicable for determination of seniority. Officers of different streams selected in a particular year, even though they were allowed to join the post on different dates, shall not affect their inter-C seniority, which is to be decided on the basis of roster. So this is what the court has mandated. Otherwise, my lord, I should not finish this point without stating this Punjab and Haryana High Court relies on Parmar's case. Now, Parmar's case in Megachandra was held to be not good law by 3 honorable judges. Subsequently, a bench has referred Megha Chandra to a larger bench saying that no, Parmar is good law. Those three judgments in a compilation, I will hand over to your lordships, my lord. But that is the factual position of the Parmar. That larger bench is pending, but your lordships is in that larger combination, and that may not hold your lordship's hands in taking whatever view your lordship feels is the correct view. And especially, we will make it small. I will just put those 3-4 judgments together and then pass on to your lordships in a compilation.
Reference on what point?
Pardon me?
In Parmar, that
Megha Chandra said, you cannot get seniority from a date before which you are born in the cadre.
that's right.
Parmar said that date of occurrence of vacancy and initiation of process or issuing advertisement is the relevant date. It will relate back. Parmar is those income tax officers, my lord, case. So Megha Chandran, relying on the subsequent judgments which said seniority can only be from the date you actually join the service, you cannot get earlier, said Parmar does not lay down good law. Then, but in a later combination, Justice Oak had actually referred it to a larger bench saying that no, Parmar does lay down law is correct and that reference needs to be relooked at. So that is where Parmar stands today.
Reference was decided by 3 judges.
Yes, references by 2 honorable judges, my lord. References by 2 honorable judges, and it is referred to a larger bench which is still pending. We pass the following order. We are of the considered view that following questions need to be decided. Whether the decision in the case of Megha Chandra can be said to be a binding precedent in the light of law laid down by the Constitution bench in Mervyn Contino and the law laid down by coordinate bench in Subhash Reddy. Then this exactly what that Parmar is right. This is what has been referred. So it will come before 5. That will not hold your lordships back. While looking and considering and reconsidering, the only problem in this seniority on roster is if one process gets unduly delayed, then the problem comes. If it happens within the year, there is no problem at all. It is the best way forward because then you are giving all 4 categories a representation in every block of 4. Because roster is 2, 1, 2, 1, 2, 1, 2, it will go on. And in case vacancies are, promotees are more, they will bunch below for that year. And next year, a fresh roster will be there. Fresh seniority will be maintained. But the only problem is if there are 2 years, 3 years delay, as in Delhi, and promotees come, that if your lordship will take care of that, and according to me, there can be because your lordship is focusing now on judicial services and removing imbalance in judicial services. So some framework, some scheme, some could be made by your lordships, my lord, in this combination, that the delay is minimized and does not in any case exceed 1 year, because that 1 year's buffer is there. Next year select list at the earliest will come into existence in September of the next year. So even if a process is delayed by 1 year and completed before September of the next year, still this can work. This system can work, and it will give a good result, my lord, if it works. Because so, my lord, this is my submission on quota, and this is actually my solution also, my lord, before your lordships. Now, roster. Now, my lord, so far as quota is concerned, the next point on quota, my lord, the point is that quota is really, Lokinath says on source of recruitment, it's not possible. I mean, so therefore, my lord, if your lordship just wants to make a note on the side of it, the crucial 2 paras of the Lokinath are at page 789 of the judgment as it is presented before your lordships. It doesn't have paragraphs. It is page 49, at page 49 of volume 5A. Otherwise, my lord, in the SCC judgment, if your lordship would look at the SCC citation, the relevant paras are 45 and 46. But my lord, so far as Delhi is concerned, my clients whom I am representing, and therefore in quota we have put our second point. We are very happy with the amicus's suggestion. And therefore, my lord, while pointing out that this perhaps is not judicially possible, then what I have said is, alternatively, it is submitted that in the event this court comes to a considered decision that it is necessary and required for a quota to be provided, then, my lord, our submission is what the amicus is saying. 1:1, he is saying, we are quite happy with that.
Atwalya, what is your response to Jagannath?
Two,
Jagannath versus Union of India, 1992 supplement to SCC 105, paragraph 45 of the amicus's brief.
para 45 of the amicus is?
Brief. That is one case where Cherokee is considered and the experience is taken as a parameter for classification.
Huh?
That's the only case where experience has been taken.
Page 45,
Paragraph 45.
para 45. In Jagannath, my lord, yes, there also, my lord, in fact, it is, the facts are totally different. The facts of Jagannath are totally different. Huh? There, my lord, the facts were totally different, actually. Yes, it's at page 292, at 296. In fact, this is, my lord, of compositors working in government presses and the relief. My lord, these are totally different facts in which those observations are made. In fact, it's very crystal clear in more than one occasion, and this is on pay scale. If your lordship will see, it is obvious from the recommendations of the committee that highly skilled category was created to handle nature of work which involved higher skill. The compositors with longer service who were found fit for promotion were appointed to grade 1 and categorized at highly skilled. Since merit, there is a valid basis. This is, my lord, this is different. It is on some merit and skill.
The subclassification.
Correct.
And the parameter, the object and the subclassification on experience was held to be a good rational nexus.
But here the experience is the same for everybody, my lord, because here we are all part of the same cadre. Here you are doing the classification.
Your case here would be that the experience here is of the district judge entry level.
Correct.
And not the experience prior to.
Correct. And therefore, you are now going to classify them on the basis of their birthmark, their source of entry. That is held to be not valid at all. Yes, yes, yes. In fact, in 2002, the judgment also, this weightage has been, in the All India Judges case, para 30, which I have quoted, it has been categorically disapproved, which is subsequent to this judgment. Then, my lord, lastly, I have dealt with that one suggestion of the amicus that they should have 50% in the zone of consideration. You should include both 50% from the direct and 50% from the promotees. That will not solve any problem because the zone of consideration is always 4 or 5 times the total number of vacancies. Now, if the promotees are higher in the cadre and direct are below, or if direct are higher and promotee are below, and you pick up equal and put them in the zone of consideration, when you will make a common list, a senior person will remain on top of that list. The junior will remain. For example, in Delhi, in my case, promotees are occupying all the top posts and we are at the bottom. Even if 50% of us are taken in the zone of consideration, we will remain in the below 50% and the number of vacancies are much less. So people from the top will be taken and that will be completely a mirage. It will not solve anything. We will just go in the zone and come back from there. So, my lord, that is my submission to your lordships, my lord. I'm very grateful, my lord.
What should a value in a case? Yearly recruitment is fine. Ideally, that those 2 points of you can have a block of 4 and 2 to promotee, 1 to ALSC and the other goes to direct. So that is on an ideal situation where, according to you, that if it happens within 1 year. Now, because of any unforeseen circumstance, if direct recruitment does not take place in a year, and it's not a question of within next year or so, if sometimes suppose it takes 4 years, 5 years, there is no recruitment, or there is a single vacancy, the High Court takes a conscious decision that why should they undergo the entire selection process After all, the selection process itself is a costly affair. So why should they undergo for one vacancy? So they wait for another vacancies to arise. It may take 4 years, 5 years. And then the direct would claim those roster points. What is,
So for the second part of your lordship's observation, the answer is simple. Where the High Court decides not to put that vacancy in the public domain, there that vacancy then is not coming. It's on the year when the vacancy is put in the public domain that I will make my application. But yes, there is a problem in the first part of your lordship's observation that what happens when there is 4 or 5 years delay. Now, my solution to that is twofold. One, your lordships can put in place a mechanism that the delay doesn't go beyond 1 or 2 years. But if it does, then the only way that the submission can sustain is
then rota is deemed to have broken down?
that is, yes, that is one answer. Then we go to length of service. For those facts, then, my lord, your lordship will leave it for the courts to cross those bridges when they actually come to them. Because today your lordship is laying down a general principle. In a general principle, I feel that your lordships could say in the same year or make some safeguard that it doesn't go beyond the next year. And then your lordship can mandate that where it is unduly delayed, the courts will examine the facts. My answer, hypothetically, academic answer will be, he should get it from the date it is actually put in the public domain. Not the second part, your lordship says, if there is one vacancy, High Court says, I am not going to circulate one. We will do it next year. We will circulate 2 or 3 together. Nobody can have a claim to that one which is never circulated. To say, no, it actually arose in that year, therefore put me in that slot. My argument is not going that far. I'm only saying on the year in which it is circulated, and all 3 streams are circulated, because Malik Mazhar says, calculate the vacancies by February, 1st February, calculate also those which are likely to arise during the year, add also 5 or 15%, which is reduced to 5 later of anticipated, and then circulate.
This can very openly it can happen in the case of direct recruit. Reason is very obvious. First, you have only 25% quota. Then direct recruits are expected to join at a younger age.
Correct.
Therefore, their retirement, their resultant vacancy will arise only if they are elevated or they retire. Or maybe.
Correct.
So
But
therefore, the occurrence of vacancy within direct recruit 25% quota will be
far less.
Will be quite slow.
Correct.
As compared to promote.
Correct. Your lordship is right. And therefore, every judgment says those vacancies have to be calculated on cadre strength. So if promotees are retiring, the direct can't get a piece of that cake. That is all promotees vacancies. So, my lord, that is actually the submission before your lordships, my lord. And my actually point is that rota quota seems to be the best answer to this problem. I am very grateful. I'm grateful.
Thank you.
Lord, may I be excused for some time there?
Yes, they're all.
Grateful.
Yes. True.
Milord, the basic issues, Milord, you have now heard. So, Milord, I am going to only, Milord, see whether, Milord, I can meet some of the, Milord, propositions which have come from the other side. But before that, may I, Milord, summarize the scope of the inquiry? Your Lordship framed an issue. What should be the rule of seniority? Now, this is a case where there is already a rule of seniority indicated in the All India Judges 2002. And that is, my lord, rota. Therefore, the question is, my lord, really whether there should be a change in the rule of seniority. Now, in order to bring about this change, my lord, whether there should be or should not be, my lord, the amicus's application is for a particular purpose. The purpose is to have better representation of promotees in principal district judges. So, my lord, we are not generally considering, or at least, my lord, there is no argument that there is a general failure of the rota system. And therefore, the rota system should be replaced by some other system altogether. That's not, my lord, the scope of this proceedings. The scope of the proceeding is whether the rota system should remain in the light of the question as to whether this is giving proper representation to the promotees or not. Now, if that is so, my lord, one has to find out what is the reason, whether, first of all, whether there is such a problem, and secondly, what is the reason for that problem arising within the rota system. Because if we don't do that, my lord, then merely prescribing another rule to correct one anomaly, my lord, will not, my lord, rectify the situation as such. That's my submission. So, my lord, what I wish to point out first is this, my lord, that it has to be empirically determined, my lord, whether in fact there is a problem or not. And I'm saying this, my lord, I said this, my lord, even when your lordship was fixing the date. But, my lord, I'm reiterating it because different states have different, my lord, figures. Now, question as to whether the promotees are getting a fair share of the principal district judges post differs from states to state. And in the state of West Bengal, the current position is that there are 59 posts for principal district judges, and only 27 of them are direct recruits and 32 of them are promotees. And, my lord, it is not even 1:1. It is more than that. Promotees have a higher share. Now, there is no reason why, if that is the situation.
But where is their placement?
Whether
the directs are above in that list of 55,
yeah,
and the promotees are below down,
no,
or they are in rotation.
no, they are in the normal course of seniority, my lord. I will have to, my lord, I want to show your lordship the West Bengal rule and the West Bengal SOP for the purpose of going to selection grade and super time, because it's very detailed, my lord. And, my lord, these are rules which have worked fairly well, because we are finding, my lord, that the promotees are not discriminated at all in the cadre of, not in the cadre, my lord, in the posts of principal district judges. Now, if the principal district judges post is under the rota rule itself capable of generating a situation where the promotees are having equal or even higher representation, then, my lord, there is no reason why, my lord, the rota rule should be replaced by something else today. So, my lord, I would submit, my lord, that the amicus can even assist, my lord, to this extent, collect the figures state-wise, only that. How many principal district judges in every state? Is there really a problem in every state that, or even in the majority of the states, my lord, that the promotees are not getting a fair share? I would respectfully submit, my lord, that may throw a light on the situation, that this problem is not as significant as has been made out to be. And, my lord, there will always be, my lord, anecdotal situations, such and such person did not get a proper share, etc., etc. But that will, my lord, not be the basis for changing a principle which your lordship said in All India Judges was the one which is least likely to lead to disputes and heartburn. That was the language, my lord, of All India Judges your lordship has seen. If, however, it is found that in most situations, or in most states, the promotees are not getting their fair share despite the rota system, then we have to see why that is happening. Because on the face of it, the rota system is meant to give far greater representation to the promotees than to the district, to the direct recruits. Yes, while that is the point, Millard, I want to show you, lordship. There can be many ways of, Millard, running this rota system. The way it is run in West Bengal and, Millard, I believe in the state of Gujarat and other places also. The first three go to, Millard, the promotees. In the rota 1, 2, 3, then 4. The first three go to promotees. The fourth one goes to the direct recruit. So, Millard, if this is working, in that event, Millard, 75% of the senior most persons, Millard, will be promotees, not direct recruits. Now, to lose that and have a 1:1 situation will actually go against their interest. They have a 3:1 situation today if the rota system is working.
That's for entry level in the edges.
No, in the entry level, yes. Now, in the,
But
Now-
not for the super time and,
now therefore, my lord, your lordship will have to see how you get to selection grade and super time. My lord, I'll just want to show you, lordship, the way it functions under the rules in West Bengal. My lord, the rules are there in your, oh, this is my copy. My lord, we have given it to your lordship because the nodal council has only given half of the rules, my lord, and one of the main clauses is missing there. These rules were formulated in 2004 as in an aftermath of the All India Judges case. Because in West Bengal, my lord, at that point of time, there was no direct recruitment at all. Since 1977, my lord, there was no direct recruit. So therefore, my lord, a complete overhaul was made in the rules in 2004 to give effect to the judgment. Please see 24, 25 and 26. 24 is internal page 6. Because, my lord, if I have a concrete model in front of your lordship, my lord, it may be easier to explain the point. Lordship sees 24 cadre. The higher judicial officers in the rank of district judges of the service, as mentioned in part 2, shall include the following posts forming the cadre, namely district judge in selection grade, district judge in super time scale. The strength of the cadre of the service shall be as specified in Schedule 4, and the government, in consultation with the High Court, may vary such strength from time to time. Then, members of the service. On and after coming into force of these rules, the higher judicial officers in the rank of district judges recruited to any of the posts as mentioned in Sub-Rule 1 of Rule 24 in accordance with these rules shall be members of the service. Notwithstanding anything contained in the foregoing provisions of this rule, the higher judicial officer in the rank of district judges holding substantively or in officiating capacity of the post referred to in Sub-Rule 1 of 24 shall, prior to the commencement of these rules, be deemed to be members of the service. Now, 26 is very important, my lord, because this is given effect to, my lord, by your lordships in the Malik Mazhar case thereafter. Method of recruitment. On or after the commencement of these rules, the appointment of the higher judicial officers, etc., in the rank of district judge in the post of district judge is mentioned in clause A of Sub-Rule 1 of Rule 24 shall be made. A, by direct recruitment from bar. B, by selection through promotion on the basis of merit cum seniority and passing of a suitability test. So this is already there, my lord, in our rules. What your lordship indicated in the May judgment. From among such judicial officers other than district judges, as mentioned in clause B of Sub-Rule 1 of Rule 6 of these rules. Then C, by promotion strictly on the basis of merit through limited competitive examinations of such judicial officers, etc. So A is direct, B is promotion, C is limited competitive. Now, provided that the number of vacancies to be filled up by direct recruitment as stated in clause A shall not be more than 25% of the total permanent strength, and such recruitment shall be as far as possible be made annually. Just see this, my lord. This is, my lord, the rota system will break down if, my lord, you do not at the same time create lists of both and then go by way of the rota. Provided further that the number of vacancies to be filled up by promotion as stated in clause C shall, subject to the provisions of the third proviso, not be more than 25% of the total permanent strength, and such recruitment as shall be possible as far as possible to be made annually. Provided also, now this is very important, my lord. This is where, my lord, the carryover formula was rejected. So what happens, my lord, if the district judge direct recruitment is not there in a particular year, then it gets filled up other than by way of, my lord, direct. Provided also that where suitable persons are not available for appointment to the post of judicial officers in the rank of district judges under this part, the number of vacancies required to be filled up by direct recruitment as stated in clause A or by promotion as stated in clause C shall not be carried forward. So direct recruitment and limited competitive will not be carried forward, and such vacancies may be filled up. A, in respect of vacancies required to be filled up by direct recruitment as stated in clause A, 1. Firstly, from amongst eligible judicial officers in the rank of district judges selected by the method as stated in clause C. So first, look at the limited competitive list. Then secondly, from amongst the eligible judicial officers in the rank of district judges selected by the method as stated in clause B. So therefore, then go to the other promotees. Then B, in respect of vacancies required to be filled up by promotion on the basis of merit as stated in clause C, that is limited competitive, from amongst the eligible judicial officers selected by the method stated in clause B. So, my lord, nothing is left over. This is how the rule is supposed to function, and it is supposed to function annually. And my lord, Malik Mazhar was designed to report back to see whether it is functioning annually or not. And my lord, by and large, my lord, your lordships were able to do it, my lord. Maybe in some states it has not been ideal. Then, my lord, 2 is not so relevant, my lord. Now now I come, my lord, to the next aspect, how to go once you enter. Once you enter, how do you go from there to selection grade and super time scale? That is only, my lord, a
But
SOP.
2 is relevant.
Sorry,
2 is relevant insofar as adjustment to senior scale and
yes, I'll place it, my lord. I'm very sorry, my lord. I'll place it. The appointment of the higher judicial officers in the rank of district judges in the post of district judge in selection grade and district judge in super time scale, as referred to in clauses B and C of the sub rule of Rule 24, shall be made by the High Court by selection of the higher judicial officers in the rank of district judges of the service from posts as referred to in clause A and B, correct, my lord, respectively, and of that rule, and such appointment shall be made by selection on the basis of merit cum seniority, correct. Now, in this merit cum seniority is given effect to by way of, my lord, an SOP, which I am placing a slightly older one, my lord. Please only look at the revised one because it has already got revised. Just see the revised. This was prepared. Please.
31, because that's the problem.
All right.
The seniority has to be worked out.
All right, certainly. See,
31 is the.
31. 31, my lord, I'll place
Yes,
31. No
seniority.
difficulty. Seniority. My lord, may I place seniority, my lord, because my learned friend is pointing out. The seniority of the higher judicial officers in the rank of district judges appointed to the post as referred to in clause A, B, and C of sub rule 1 of Rule 24 shall, unless reduced in rank on account of punishment, be determined in accordance with A, the date of continuous officiation in service in case of officers promoted to the post as referred to in clause A, B, the date of order of appointment in the case of direct recruitment to the posts as referred to in clause A, the date of order of selection to post as referred to in clause B and C respectively, as may be specified in this regard by the High Court, provided that in the case of direct recruit or promotee under clause A, B, and C, as the case may be, of 26, to the post referred to in clause A of sub rule 1 of Rule 24, if the date of continuous officiation of the higher judicial officer of the rank of district judges promoted to such post and the date of joining / appointment of direct recruit be the same, the inter se seniority shall be fixed according to the 40-point roster as determined by the High Court from time to time, provided further that the seniority amongst higher judicial officers, etc., promoted by an order of the same date or amongst direct recruits appointed on the same date shall follow the order in which their names have been recommended by the High Court, provided also that the relative seniority of the judicial officers of the West Bengal, etc., coming appointed prior to the coming of date, that we are not so much concerned with. So therefore, my lord, this makes it official to follow the 40-point roster also. That's the scheme. Now kindly come to, my lord, having entered, how they will move up. Just see page 1 only. This is just 2-3 pages. Selection grade scale of pay. The revised as is relevant. Point number 4. The officer should not have been graded F poor. This is the SOP. This was not in the record. The rules were in the record but partially given. But this is, not on the record. I am just showing your lordship. Yes. This is the resolution of 2022. It gave existing and revised. But the revised came in, so I am not troubling your lordship anymore with what was existing then. The officer should not have been graded F poor during the last 3 years and should not also have been graded E average more than twice during the said period of 3 years. Then super time scale. The officer should not have been graded F poor during the last 3 years and should not have been graded E average more than once during the said period of 3 years. And then, the norms are revised as grading of officers A, outstanding, B, very good, C, good / satisfactory, D, above average, E, average, F, poor. So, my lord, after this, so first of all, my lord, when you are creating the zone of consideration, you eliminate those who have not performed. Only that category is eliminated. The rest of the people who come into the zone of consideration on a 3:1, on a 3:1 basis, my lord, depending on the number of vacancies in those my lord, scales of pay, the zone of consideration is after that, my lord, only on seniority. So, my lord, the seniority that is there at the entry level will reflect in the selection as well as in the super time, my lord, scale, subject only to this, that if performance has been poor or average, then they fall by the wayside. So in any event, my lord, there is no question of giving them, my lord, any faster avenue to principal district judges anyway. In fact, my lord, we are not, what happens therefore is, my lord, the super time scale of pay, my lord, persons are inevitably, my lord, all of them are accommodated as principal district judges or equivalents. After that, what is left over, my lord, comes from outside the out of the selection grade. So therefore, my lord, my lord, the result is this, my lord, that who will make it to the post of principal district judge now depends on two factors only: your seniority at entry level and your performance. Now, it cannot therefore, my lord, become a quota in the higher pay grades because there is, my lord, a merit criterion there. There cannot be a situation where you are not entitled to enter that zone of consideration, but because there is a quota, you should go to the top. That can't be.
That is the board criteria in every state.
Yes, correct, my lord.
That is what the roster points or the quota or the rota is only at the recruitment level, at the initial recruitment.
Yes.
It all depends upon merit and your selection.
So, yes, my lord. So therefore, what I am submitting is, my lord, that if the seniority rule is correct at the base, then, my lord, it will reflect on the principal district judge also, subject only to performance.
That comes in.
Yes.
That selection grade and super time scale
Yes.
is not something that it is available to the entire cadre. There is
No.
a cap. Normally it is 15%.
15%, yes, correct. 35 and 15, yes.
Have already articulated the entry into service.
Yes.
And seniority point in the beginning.
Yes.
That somebody who is pushed behind, he will not reach within the 15%. Then irrespective of the principle of seniority, he will never get it.
Correct. So therefore, my lord, your lordship is investigating whether at the entry level, the seniority is being fixed in a manner which will prevent them from reaching in a fair manner, reaching the post of principal
That is
district.
precise issue.
Right, quite right, my lord. That is the only inquiry. My lord, we are not here, my lord, generally investigating as to whether the rota rule has worked or not worked, etc., etc. Now here, if that is so, my lord, if in the initiation itself, in the entry level, if the first three posts are going to promotees and the fourth one is going to the district judge, then there is no question, my lord, of there being any unfairness anywhere up and down the service.
That will be your point.
Lordship, my lord, that is what I am trying to say, my lord. And so therefore, my lord, taking this concrete example, your lordship may consider whether it is really necessary to refix, my lord, the seniority rule as per rota by any other process. Now, three suggestions have been given. The first two require the seniority to be refixed within the cadre as time goes on. My lord, just have a look. My lord, this is, my lord, in the amicus's submissions, right at in paragraphs, right at the end, suggestion 1, suggestion 2, suggestion 3. Page 48 of, my lord, PDF 52, page 48. The first suggestion is, may I read, my lord?
Yes.
The additional experience as judicial officers constitutes a reasonable and justified classification on the basis of which promotee district judges can be classified as a category who ought to be granted a quota for their effective representation at the post of district judge selection grade, district judge super time scale, etc. The creation of quota satisfies the twin test of classification based on integral differentia and reasonable nexus of such classification with the object sought to be achieved. Therefore, creation of such quota is permissible under Article 14, etc., etc. Now, my lord, I respectfully submit, then you are changing the seniority rule. Once they have entered the service and they have a particular seniority rule, a new seniority rule will have to come into effect at the selection grade and at the date of super time scale. Lord, that, my lord, is not correct in my respectful submission. Now come to the second suggestion. Alternatively, a zone of consideration for appointment to the post of district judge selection grade and district judge super time should comprise of 50% officers from the direct recruited district judges and 50% promoted district judges. Thereafter, the appointment would have to be made on recommendation on the basis of merit cum seniority. Thus, in a zone of consideration, 50% officers would be senior most promotee district judges and 50% would be senior most directly recruited. Again, bifurcation of the cadre. And not only that, my lord, suppose there is already a 50% criteria to the super time scale. Then after that, where is the merit cum seniority? You have to place them. In selection grade and super time scale, since merit comes into the picture, there can be no quota, in my respectful submission. But look at suggestion 3, my lord. The weightage suggestion, my lord, is of course something which your lordships are considering, and this is not, my lord, an unacceptable suggestion. Otherwise, I will indicate why, my lord, it may not be appropriate in this case. So first, my lord, I place the suggestion. Alternatively, it is suggested that they may accept the recommendation of the Shetty Committee and grant weightage to promotee district judges for experience in terms of 1 year seniority for every 5 years of judicial service, subject to maximum of 3 years. It is further submitted that these additional years of seniority may be considered as service in the district judge cadre. Thus, if a promotee district judge has been granted 3 years seniority as per the aforesaid criteria, such a promotee district judge will require only 2 more years of service in the district judge cadre for being considered for grant of selection grade. It is stated acceptance of the recommendation of the Shetty Commission will require modifying or dispensing with the 40% roster system of seniority, etc. So first of all, my lord, suggestion 3 recognizes that no change is proposed to the entry level. Seniority will be as per roster in the entry level, but the seniority will change at selection grade and super time scale. But here, in the third one, my lord, what is happening is that they will be given weightage based on their service in the lower cadres. That is, my lord, civil judge senior, civil judge junior. Now, my lord, there is a big problem with this. My lord, inevitably, this means that the longest serving district judge will always be senior to everybody else. This pushes down not only, my lord, direct recruits, it will push down those direct recruits who have been district judges in the, who have been, my lord, civil judges in the past and have come in by way of the direct recruitment quota as per your lordship's judgment in Rajneesh. It will also push down, my lord, the competitive, limited competitive, because the limited competitive people have necessarily had less experience as a civil judge, my lord, than those who have entered the service and remained in it all the way till promotion. So, my lord, to give this weightage is reordering the system in such a way that the senior most person in the lower cadre will necessarily be the senior most person in the higher cadre. That is not, my lord, the purpose of all this exercise. The purpose of the exercise was to pull up people who were bright and who were not yet, my lord, at the level of, my lord, getting promotion. The LCE was also for that purpose. Direct recruitment is for that purpose. The direct recruitment of district civil judges pursuant to your lordship's judgment is for that purpose. The purpose is not to push down merely based on their seniority in the lower cadre. That's why, my lord, the weightage based on experience in the lower cadre may not be, my lord, an appropriate way to improve the functioning or the efficiency of the judiciary. So, my lord, this is why, my lord, we are saying that go back to the original and see why it is not working if it is not working. And if it is not working in a particular state for some reason, it can be corrected. I give an example, my lord. In the West Bengal model, admittedly, the promotees will be senior to the direct recruit at the entry level. Suppose, my lord, another state, and my lord, initially, I don't know if that is the position today, but initially, my lord, Andhra Pradesh had followed a model where the direct recruit was on the top and the promotees came after that in the roster. Now, if this led to a system where sufficient representation was not being given to promotees at the top, then, my lord, the correct thing to do is to change that to make sure.
Now they have changed the rule. They are maintaining two different seniority lists for direct and for promoting in Andhra as well as in Madras High Court.
My lord, I believe, my lord, all these have to be documented. That's my view, my lord.
So yesterday there was a petition for filers before us.
Yes. So just see, my lord, it can be rectified simply by imposing, my lord, the correct rota. Yes. Yes.
Is in fact referring to the Andhra Pradesh lists,
Yes.
separate lists for the promotee and the.
Yes. My lord. But this is, my lord, ex facie, my lord, it breaks up the cadre. It breaks it up. My lord, the kind of rivalries that will develop is, my lord, unthinkable. But, my lord, this makes my point, my lord. The point I'm trying to make is maybe smaller fixes are necessary. Maybe, my lord, states where the direct recruit is going to the top at the entry level should be changed to bottom. Maybe the, my lord, these separate lists should not be maintained. Simpler solutions may be there without breaking down the rota system. And then, my lord, if the rota system, my lord, is creating, in some cases, my lord, a problem, my lord, kindly look at it this way, on a matter of principle. If on principle a particular rule is correct and appropriate, then the correct way to sort out any difficulties arising with it is to revert to it rather than to, my lord, take it away also. Yes.
What is your take on this, that the Andhra rule of the cadre
Yes.
being put into three separate seniority lists on the basis of source of recruitment,
Yes.
will it hold good in light of the ratio in question?
It won't, my lord. It cannot. They have to be, my lord, at least at the entry level, they must be, my lord, equal. At least at the entry level. Except, my lord, if there is weightage to be given, and that weightage, my lord, your lordship knows, my lord, these weightage cases all arose in the context of educational qualifications.
Weightage, Mr. Gupta, was in fact the inspiration for the amicus, we understand, is the Shetty Commission report,
Right.
which was not accepted in the 2002 judgment.
Right, my lord. Correct. But, my lord, to go back further, where did the rule come from? The weightage rule. Most of them came from, my lord, different educational qualifications. Degree, diploma, this, that, and the other. Now, everybody had an option of getting those. But here, my lord, the direct recruitee cannot possibly get experience in the lower cadre. And the person who is in the lower cadre will necessarily have an advantage if you give this weightage. Always. Now, my lord, only one other question I'll address, my lord, and because I have participated, my lord, in the Malik Bazaar for years and years and years. Now, it is true that, my lord, every time high courts do come up with applications saying that for X, Y, and Z reasons, we haven't been able to stick to the time frame. But your lordships, my lord, make sure that within the year it is done. Every year there is a vacancy list published, and, my lord, a schedule is set and that schedule is followed. Now, there, my lord, the date which is supposed to be relevant is 31st of December of the year. Now, on 31st of December, to the extent that it has been possible to give effect to it, there is no difficulty in giving effect to the rota. If suppose something is left over, for some reason, my lord, somebody, the examination for direct recruitment hasn't taken place, etc., etc. Then, my lord, unfortunately, given that Meghachandra Singh is the current law in place and has not yet been overruled, they should not, of course, be given seniority from a date prior to their service, coming into service. Then, my lord, they will have just out of necessity, they will have to be given seniority on the date of appointment. There is no option. But every time there is a date of appointment, if there is more than one category feeding that day, if there are promotees as well as direct recruits coming on that particular day, then my lord, the rota system will apply to all of them on any day that there is more than one source. But my lord, it should be possible, and over a period of time, my lord, I'm not sure exactly today, but your lordships have amicuses in the Malik Mazhar matter, region-wise amicuses. There were 4 amicuses at one point of time, even now. So therefore, my lord, it ought to be possible, my lord, to ensure that this system keeps working, and after some years, my lord, it ought to become self-perpetuating, my lord, in my respectful submission. So, my lord, these are my submissions, my lord. Deeply obliged.
May it please the Lord. Sir, I appear for the applicant in IA number 26784, Harsh Agarwal. He is one of those, my lord, who was a civil judge, took the direct recruitment exam under interim orders from the High Court, and is the beneficiary of your lordship's other judgment in Rajneesh. So now he is a direct recruit. And my submission is going to be slightly nuanced because in a sense he's both. He has experience of being a civil judge, as also he is now a direct recruit. Lord, your lord, this entire case started from your lordship's order.
When did he become a direct recruit?
2014 is the date of the exam.
At that time, it was not permissible.
I'm sorry, my lord.
At that time, it was not permissible for a judicial officer.
No, he took, my lord, the exam under interim orders of the High Court. Now those matters are listed before your lordship day after tomorrow on the 6th, where your lordship will decide what is to happen in each case. And we expect, my lord, that he will get the benefit. Yes, he will get the benefit because he is under the 4 corners of your lordship's
So
order.
how you change the sides?
That's true. Although I'm appearing for the same people.
In that matter, you argue from this side.
Right, right. Now, my lord, this entire case started, if your lordship has the note of the amicus, the written submissions of the amicus, from your lordship's order dated 7th of October 2025. And I just want to read that because that is the sort of fulcrum of how this case started. Page 1 of the amicus's note, or if your lordship has the order separately, my lord, this is the 7th October 2025. This court, with a order dated 17 September 2025, had considered an application filed by Shri Siddharth Bhatnagar, learned amicus curiae, who had pointed out an anomalous situation, that is, in most of the states, judicial officers recruited as civil judge often do not reach the level of principal district judge, leave aside reaching the position of High Court judge. This has resulted in many bright young lawyers being dissuaded from joining the service at the level of the civil judge. So your lordship's, my lord, attempt was that it should not be a situation where people are dissuaded from joining as civil judges because they feel stagnated. They don't reach senior scale, they don't reach district judge, etc. for a very, very long time. It may take several years. They don't even reach ADJ level for about 13, 14 years. And therefore, they feel very, very frustrated and stagnated. Now, that issue of stagnation and frustration and therefore leading to good people not joining, according to me, my lord, has been sorted out by a lordship's judgment in the other case. that Rajneesh. Because now there is no question. After 7 years combined as lawyer and civil judge, either 700, 734, whatever combination, 7 years combined, you can now take the higher judicial service exam, subject of course to achieving 35 years, which is on parity with direct recruits. So therefore now the bright people, which your lordship was worried about in this order, many bright young lawyers being dissuaded from joining the service at the level of CJ, they can't have any grievance. Along with the direct recruits, you can also take the exam at age 35.
So had you lost in Rajneesh,
Yes.
you would have been on this side.
Could be. Could be. But ultimately, we have to argue our client's case from.
No, I'm talking about your client.
And of course, we have to assist your lordship, my lord. So therefore now, my lord, insofar as these bright young lawyers who want to join as civil judges, they cannot have a grievance that, look, we will reach the principal district judge at a very late age. Because you have the right to take now the direct recruitment exam at age 35, just as lawyers do. So you can't say, well, they will reach there at a younger age, I will not reach there at a younger age. So therefore, my lord, that problem is sorted out. So today, that issue on the basis of which this case started, in my humble submission, my lord, has been sorted out. Now, it was suggested by the amicus that no, this system of being able to take direct recruitment exam will not work because otherwise they will be all the time working for this exam and not be doing their work. That may not be quite correct. For the reason that there is no guarantee of your succeeding in the exam, and therefore your ACRs are very important. Supposing you don't succeed in the exam, your ACRs are important. So you can't say, no, they will not do their work. In any case, that is now not concluded aspect, that they are now permitted to take the exam by the other constitution bench. So, and it is incorrect in my humble submission to say that they will not be doing their regular work. Just as lawyers, they do their regular work also while preparing for this exam. Similarly, it is unfounded to say that civil judges will not be doing their regular work of being a civil judge and only be not engaged in preparing for the exam. So that is not one thing I wanted to get out of the way. Now, Lord, ultimately, the issue is, should there be any quota or any benefit given to civil judges for reaching the higher scales, the super time scale, the senior scale, etc.? Now, any quota is, my lord, admittedly a departure from merit. The moment you say that we are going to give them a quota, now if your lordship sees, my lord, their suggestions, the amicus's suggestions, according to me, my lord, of the 4 suggestions, 1, 2, and 4 are all based on quota. 3 is giving an additional 1 year for every 5 years of service as civil judge, some sort of a leeway, and that is not quota in a sense, but an additional benefit. But 1, 2, and 4 are all quota. Even 4, if your lordship sees. 4 is all the more quota because what he is suggesting is 3 separate seniority lists, and they will be for selection to higher posts, that ratio of 50, 25, 25, which is the initial ratio for appointment of district judges in the cadre, that will be maintained. So that is exactly a quota. Now, Lord, my submission before your lordship is that for higher posts, merit should be the most important criterion. That is an accepted fact. And I want to refer to one constitution bench judgment. We given that compilation. We have just handed over compilation. And in that compilation, this is the very first judgment. ये कहाँ पर है? समझते हैं बस। जो SCC का है। Nine. Your Lordship turns to page 11. I am reading from the fourth line or the fifth line. Mr. N.C. Chatterjee argued, does your Lordship have that, Manoj?
Yes.
That the introduction of the idea of merit into the procedure of promotion brings in an element of personal evaluation, and that personal evaluation opens the door to the abuses of nepotism and favoritism. And so there was a violation of the constitutional guarantee under Articles 14 and 16 of the Constitution. We are unable to accept this argument as well-founded. The question of a proper promotion policy depends on various conflicting factors. It is obvious that the only method in which absolute objectivity can be ensured is for all the promotions to be made entirely on the grounds of seniority. That means that if a post falls vacant, it is filled by the person who has served longest in the post immediately below. But the trouble with the seniority system is that it is so objective that it fails to take any account of personal merit. As a system, it is fair to every official except the best ones. An official has nothing to win or lose provided he does not actually become so inefficient that disciplinary action has to be taken against him. But though the system is fair to the officials concerned, it is a heavy burden on the public and a great strain on the efficient handling of public business. The problem, therefore, is how to ensure reasonable prospect of advancement to all officials and at the same time to protect the public interest in having posts filled by the most able man. In other words, the question is how to find a correct balance between seniority and merit in a proper promotion policy. In this connection, Leonard D. White had stated as follows: the principal object of a promotion system is to secure the best possible incumbents for the higher positions while maintaining the morale of the whole organization. The main interest to be served is the public interest, not the personal interest of members of the official group concerned. Please mark this, my lord, because I will be making a submission on this. Now that, my lord, your lordship has sorted out the system, the problem of good people not coming into the cadre of civil judges by the other judgment. Now, Lord, it is what we are dealing with now is not to sort out the problems of people who have already come in earlier as civil judges and who have not taken the direct recruitment exam. Firstly, they will be able to take it. And even otherwise, my lord, the idea is not to sort out their personal heartburns. The idea is ultimately to better the system. So therefore, it says the main interest to be served is the public interest, not the personal interest of members of the official group concerned. The public interest is best secured when reasonable opportunities for promotion exist for all qualified employees, when really superior civil servants are enabled to move as rapidly up the promotion ladder as their merits deserve, and as vacancies occur, and when selection for promotion is made on the sole basis of merit. For the merit system ought to apply specifically in making promotions as in the original recruitment. Employees often prefer the rule of seniority, by which the eligible longest in service is automatically awarded the promotion. Within limits, seniority is entitled to consideration as one criterion of selection. It tends to eliminate favoritism or the suspicion thereof, and experience is certainly a factor in the making of successful employee. Seniority is given most weight in promotions from lowest to other subordinate positions. As employees move up the ladder of responsibility, it is entitled to less and less weight. When seniority is made the sole determining factor at any level, it is a dangerous guide. It does not follow that the employee longest in service in a particular grade is best suited for promotion to a higher grade. The very opposite may be true. And this is from the study of public administration. That is that White, Leonard D. White, that was quoted. As a matter of long administrative practice, promotion to selection grade posts in the Indian Police Service has been based on merit, and seniority has been taken into consideration only when merit of the candidate is otherwise equal. And we are unable to accept the argument of Mr. N.C. Chatterjee that this procedure violates in any way the guarantee under Article 14 and 16 of the Constitution. Now, therefore, to the higher posts, whether it is the IPS, IAS, or in this case, district judges, and that too in the higher echelons of district judges, namely, my lord, selection grade and super time scale, the criterion has to be merit. In fact, the rules provide so. The UP rules, which your lordship will find, my lord, are at volume 4A, page 942. Page 9, it starts at page 934, my lord, the UP rules, the UP Higher Judicial Service rules. And if your lordship turns to Rule 27 and 27A.
Nineteen seventy-five rules.
Yes. Your lordship, Rule 27 on page 942 of that volume. And I believe, my lord, that most of the states have similar rules.
Yes.
West Bengal, my learned friend just read, Mr. Gupta, but it is also merit come.
Rule,
Rule 27 at page 942,
appointment to the
appointment to the selection grade. Appointment to the selection grade post to the extent of 35% of cadre post of district judges in service shall be made by the court from amongst the members of the service who have put in not less than 5 years of continuous service in the cadre on the basis of merit cum seniority. And similarly, super time scale, the same thing at the end, your lordship will find on the basis of merit cum seniority. That's 27A. So it has to be on the basis of merit cum seniority. That is what the Constitution bench in Santaram Sharma says, that for higher posts, it is always merit. Because that is the most important for the administration, for the benefit of the public at large. It is most important that the best people are at the higher posts. Therefore, my lord, it has to be, and that's what the rule says. So if it has to be on the basis of merit cum seniority, giving any benefit for, my lord, going up in seniority, namely 1 year for every 5 years, etc., becomes very less relevant. Once merit is equal, only then, my lord, seniority has to be taken into account. Your lordship has just seen, my lord, that from Santaram Sharma, same thing is said in several judgments. Your lordship may just make a note. 2001, 5 SCC, page 60. This is Central Council for Research in Ayurveda. It's at page 588 of the compilation. Your lordship may just mark. Paragraphs are 6, 9, and 10. I won't read them, my lord, since there is paucity of time. Then there is Haryana State Electronics and Seema Sharma versus Seema Sharma 2009 7 SCC. This is at page 593. Paragraphs are 7, 8, and 9. And BV Shivaya at page 569. This is volume 5B. Volume 5B. 1998, 6S, sorry, not volume 5B. This is the compilation that I've just handed over. My compilation. 1998, 6 SCC 720, paragraphs are 8 to 10. Now, all of them say this. Where the rule is merit cum seniority, then it will be essentially on merit, and seniority comes into play only if merit is equal. Which means that ultimately, my lord, this whole thing about roster, about this, that, and the other actually becomes reasonably irrelevant. Now, in actual practice, what happens is something quite different.
So according to you,
Yes,
if a person is more meritorious,
yes,
then even going down below the line,
yes,
he can be picked up.
yes. Absolutely right. That is what, my lord, all these judgments say, including constitution benches. For higher echelons of service, public interest demands that the best are to man those posts. And the rule also says this, merit cum seniority. And merit cum seniority has been explained in multiple judgments to say seniority comes into play only when merit is equal. Now,
All the
practically,
judgments- All the judgments which you are citing, Mr.
Yes.
Jain,
yes,
are based upon the statutory rules.
yes,
And there the rule itself contemplates
right. Merit cum
first.
seniority.
Seniority, of course, only two considerations. Seniority will bring in the zone of consideration, and seniority will then give you a
Tiebreaker.
edge if you are equally in merit.
Yes, yes.
But that is all based upon the where the rule provides.
Right, right. Now, our rule also provides this. I've just shown to your lordship, my lord, the rule also provides this. Our rule also provides this, and rightly so, because Santaram Sharma, the constitution bench says in the higher post, it is only merit which should prevail. So rightly provides this.
That's right. So your contention is that where the rule provides,
Yes.
then merit will prevail.
Right, right.
Only when the rule provides.
Correct, correct.
Suppose there is no rule.
No, I am saying, my lord, even if there is no rule, according to Santaram Sharma, the higher echelons, only merit must be there. And
Santaram also-
seniority.
In Santaram also there is a rule.
No, but Santaram quoted, my lord, the philosophy behind it. As to it was not interpreting the rule. May I read those
Santaram.
paragraphs of
In
Santaram again?
The Government of India Memorandum of 1954,
Yes,
which in the absence of rule
yes,
undoubtedly supplements the rule. And there it was contemplated that in the event of this, say, appointment on a selection post of Deputy Inspector General of Police or Inspector General of Police, merit is to follow. I mean, that you may be legally right to say that when the rule provides or even an executive instruction in the absence of rule provides.
Lord Santaram, that quotation from that White was not based on any rule. Essentially, it said what is desirable. What is desirable is that in the higher echelons of public service, it is merit which should prevail. I mean, that is what is desirable. Of course, your lordship is right as to if there is a rule which says something different, will it be struck down on the basis that Santaram says that this is desirable? That's another question. But I'm saying that apart from interpreting the rule, Santaram says it is desirable in the higher echelons to have merit. And therefore, my lord, when the rule itself provides merit, merit cum seniority, which has been interpreted in multiple judgments to mean that merit alone is the important thing. It is seniority is only a tiebreaker. Therefore, my lord, my submission before your lordship is that the proposal to have a sort of a quota to push people up the seniority ladder and therefore, my lord, get them to become super time scale, etc., on an earlier basis would militate against this, the merit rule and the merit principle. Then how do you determine now, Lord? I must tell your lordship as to actually on the ground what happens according to what I have been told by my clients. On the ground, they do some sort of a suitability test. And those who pass the suitability test are then recommended on the basis of their seniority. And therefore, seniority becomes more important, quite contrary, my lord, to this rule. That is what the high courts are doing. And that is not what they should be doing. If the rule is to be interpreted, Lord, it is the merit which is important, not that you do some sort of a suitability test, namely somebody who is completely unsuitable is knocked out, the remaining go through in order of their seniority. Actually, that's the problem. It is only because on the ground, practically, this is being done on the basis of seniority and not merit, which is the rule. That is why, my lord, this whole fight for who is to be senior, etc., has become so critical. But, my lord, I am urging before your lordship, because your lordship is sitting in a constitution bench, that this should be corrected. What is happening on the ground that broadly people are being appointed on the basis of their seniority should be corrected, because that is not in accordance with the rule and not in accordance with the principle laid down in Santaram Sharma. Now, my lord, further question may arise, how do you determine merit? Now, my lord, at the stage of promotion from civil judges to district judge cadre, there is a test, an objective type test. So it's not like you'll write an essay or anything, objective type multiple choice questions, which will determine your knowledge of law. Now, that can be done at every stage, whether it's selection grade, super time scale, etc. At every stage, this test can be done. and combine it with ACRs, of course. How you have been working, how you have been conducting, etc. Your ACRs are also important. ACRs, of course, are the most subjective and the least objective, but they certainly can't be done away with. So some sort of a combination of an objective test along with ACR is how merit can be determined. So that is what needs to be done. Now, Lord, your Lordship had asked, I'll just come to that, my Lord, about that Trilokinath, that 1974. I'll just come to that in a moment. My next submission, my Lord, is that this quota that my learned friend, the amicus, has suggested in suggestions 1, 3, and 4, what your Lordships have laid down in Indira Sani, which is 9 judges, is there cannot be a quota in promotional posts. That, of course, there was a constitutional amendment, your Lordship knows a lot, that Article 16, 4A, 4B, etc., and Article 355 were amended, but that is all about scheduled castes and scheduled tribes. Otherwise, the principle laid down in Indira Sani that there cannot be a quota in promotional posts, that of course has been watered down by the constitutional amendments, which don't apply to us. But those principles will still apply. If your Lordship has Indira Sani, starts at page 13. Your Lordship has page para 822 at page 538 of my compilation. .538 of my compilation, my Lord, paragraph 822. The compilation that I've just handed over, my Lord.
Paragraph 5.
822, my Lord. Reservation in the case of promotion, does your Lordship say that, no? Is normally provided only where the promotion is by selection, that is on the basis of merit. Or if the promotion is on the basis of seniority, such a rule may not be called for. In such a case, the position obtaining in the lower category gets reflected in the higher category, promotion category also. Where, however, promotion is based on merit, it may happen that members of backward classes may not get selected in the same proportion as is obtaining in the lower category. With a view to ensure similar representation in the higher category also, reservation is thought of even in the matter of promotion based on selection. And then they refer to Rangachari, where that promotion in the reservation and promotion had been upheld. And Rangachari is thereafter referred to, and your Lordship may only, my Lord, come to 2 pages later. 823 starts on the next page, and I just want to read, my Lord, sub paragraph B of Justice Gajen Gatkar's, my Lord, judgment in Rangachari. Of course, Rangachari was then set aside by Indira Sani, but just, my Lord, where he says.
So Rangachari was set aside by N.M. Thomas.
I see.
Seven
But
judgments.
Seven judges.
7 days.
7 judges. I see. And then thereafter, they also, not in this 9 judges, they say, keep.
This takes on no more law.
Lordship. So if your Lordship just sees D, because even in Rangachari, where reservation and promotions had been upheld, they had said that reservation of appointments or posts may theoretically and conceivably means impairment of efficiency. But the risk involved in sacrificing efficiency of administration must always be borne in mind when any state sets about making a provision for reservation of appointment of posts. So, of course, there can't be any cavil on that. The moment you make reservations in something which is governed by merit, then you are sacrificing merit in a sense or efficiency in a sense. Question is, in the balance, is it worth it or not? In the case of backward classes, of course, because they have been, for generations been disadvantaged. Therefore, they need a push up. And therefore, that was the basis, my lord, on which Rangachari had held that, of course, set aside, and thereafter the constitution was amended. Now, my lord, your lordship may have paragraph 827. I'm not going to read, my lord. They say that Rangachari does not appear to be acceptable. Now, just have 828. We see no justification to multiply the risk which would be the consequence of holding that reservation can be provided even in a matter of promotion. While it is certainly just to say that a handicap should be given to backward class of citizens at the stage of initial appointment, it would be a serious and unacceptable inroad into the rule of equality of opportunity to say that such a handicap should be provided at every stage of promotion throughout their career. That would mean creation of a permanent separate category apart from the mainstream. Now, this is what is being suggested, that you reserve 75% of posts in the district judge cadre at the entry level. And thereafter, even at the stage of promotion, you give some sort of a reservation to people who have come from the promotees, from civil judges. That would mean creation of a permanent separate category apart from the mainstream, a vertical division of the administrative apparatus.
Then scheme 4 has been brought in.
That's only for scheduled caste and scheduled tribes.
For
So therefore, my lord, this principle has been watered down only for, we are not dealing with scheduled caste and scheduled tribes. 16.4a, 16.4b will not apply. That was brought in to override this judgment for the purpose of scheduled caste and scheduled tribes. If it was a case of reservation for scheduled caste and scheduled tribes, certainly, my lord, 16.4a, etc. would have been relevant. But for our purpose, no.
Therefore, these observations may not be relevant today, insofar as promotion.
So far as scheduled castes and scheduled tribes are concerned, they may not be relevant. But so far as the principle laid down by my lord, of course, legislation cannot overrule a judgment. They can only take away the basis.
No, yes, what they say is, if a reservation is provided for scheduled caste and scheduled tribe,
Yes.
even if they work or do not work, they will be assured that they will be getting a promotion.
So
Here,
therefore,
what is being proposed by the learned amicus is not that there will be a guaranteed promotion. There will be some.
Exactly what I'm
more
saying.
weightage be given for them.
That's what I'm saying.
If they are not meritorious, they will never be considered.
Correct.
Therefore, this analogy will not apply.
No.
Analogy here is that if a reservation is provided for scheduled caste and scheduled tribe at every level, then there will be no incentive for them to work or no urge for work. They will be assured
Right.
that by passage of time, I am going to get in B.
That's exactly
by
what I'm
passage
saying.
of time, I am getting-
I
Here,
agree.
what is being proposed is not that system, that
No,
there will be a fixed quota and they will get in irrespective of the merit.
That's what is proposed.
No,
That
no.
to make a 50%
Sorry,
quota.
I don't think that is what.
But that's what a reservation and promotion means, that if
That,
there
that's
is a
not,
quota.
and that can't, that no bench would say that a meritless person or a
Lord,
person
that is
divide,
the effect of,
a person thoroughly incompetent should also be promoted
Lord,
merely because he is senior.
I absolutely appreciate. Now, the question is what Indira Sani has said is ki there will be no incentive for you to compete with the other categories, namely the direct
There
recruits.
is a compartmentalization, 25% will be reserved for scheduled caste at every level.
That's what is the fourth suggestion. If your lordship looks at the fourth suggestion, that is what it says. That the same quota of 50, 25, 25.
You have exceeded your half an hour.
I'll just very, very quickly, my lord. So therefore, my lord, in paragraph 828, this is what it says, that otherwise if you now demarcate these three streams or two streams, in our case, three streams, whatever, then my lord, that will not lead to the efficiency of administration.
So what is being proposed is demarcation of 50-50.
Even 50-50, then you are competing.
So even, it's not a compartment. So even in that suggestion, the persons who are directly appointed will have a better chance because their entry level is 25% and what is proposed is 50%. So double the number of.
That's why I'm saying that we don't want that benefit. Even though now I've become a direct recruit, I am saying for the purpose of merit, there should not be, what is encouraged is that once that stream becomes homogeneous, then you compete with everybody in that.
That's argued by everyone.
Correct. No, so I am arguing it on the basis of Indira Sani. which is
That's
9
now
judges.
being argued that once you enter a particular cadre, you lose your birthmark.
That's not, that's the sort of basic thing. What I'm saying by Indira Sani in 828, when they are saying that once you make this reservation, even in promotion, then you are competing only with your own category. Namely, once you're supposing you do this 50-50, which is what is proposed in the first alternative, then the civil judges will be competing, the promotee civil judges will be competing only with the promotee civil judges, and not because your category of your quota of 50% is assured. You are then not competing with the direct recruits, which is something which is not desirable according to Indira Sani. Of course, the constitutional amendment related only to scheduled caste, scheduled tribe, that will not apply to us. That did away with this. But otherwise, the principle that has been laid down by 9 judges will still apply. Then, my lord, at paragraph 834, whether reservations, the question number 8, 832, whether reservations are anti-meritarian.
That is answered in the negative.
Only because, so,
Rasani says that the reservations are not anti-meritarian.
right. So because there is a sort of a benefit in giving the benefit to the people who are traditionally disadvantaged. Just let me argue, don't tell me to address. The third suggestion that the amicus has given, that 1 year for every 5 years. Now, the question that arises is, does Trilokinath, because the first 2 judgments, my lord, Cortino, etc., don't permit it, but Trilokinath, they argue, has kind of distinguished them and said that they deviated and distinguished and said that, yes, this can be permitted so long as it is not from that stream. Now, I want to show your lordship, my lord, 2 paragraphs of Trilokinath, which are in the amicus's written submissions. I don't need to take your lordship, my lord, to that. If your lordship has paragraphs 45 and 46 on page 35 of the amicus's note. And I'll explain my submission to your lordship before I read them. If the classification is based on a criterion which is directly relatable. My lord, the quote, this is on page 35 of his note is the quotation from Trilokinath, and I am referring to 45 and 46. Thus all
that Roshan Lal.
Yes. Thus all that Roshan Lal's case lays down is that direct recruits and promotees lose their birthmarks on fusion into a common stream of service, and they cannot thereafter be treated differently by reference to the consideration that they were recruited from different sources. Their genetic blemishes disappear once they are integrated into a common class and cannot be revived so as to make equals unequals once again. Roshan Lal's case is thus no authority for the proposition that if direct recruits and promotees are integrated into one class, they cannot be classified for purposes of promotion on a basis other than the one that they were drawn from different sources. In the instant case, classification rests fairly and squarely on the consideration of educational qualifications. Graduates alone shall go into the higher post. No, I'm saying something a little different. Graduates alone shall go into the higher post, no matter whether they were appointed as assistant engineer directly or by promotion. Now, please mark this. Which means graduation is the classification that you are using. Those who are graduates will be given that benefit. The graduates can come from either of those 2 sources. They are not relatable only to one source. That's why I'm giving emphasis on this sentence. In our case, what the amicus suggestion is that experience as civil judges is the criterion that applies only to one of the 2 sources, and therefore it's directly relatable to the source. That is not permissible. Trilokinath did not say that if the classification that you are using is directly relatable to the source, then that is also permissible. And that is why they were at pains to say graduates alone shall go into the higher post, no matter whether they were appointed as assistant engineers directly or by promotion. Namely, graduation could be a qualification which both those categories could have. So only those persons who had that graduation would be given the benefit. There was nothing wrong with that. But what he is proposing applies only to one category, that is the civil judges promotees, and not to the other category, that is, my lord, that the direct recruits. That is not permissible. Now, alternatively, my suggestion before your lordship is, supposing your lordship were not to agree with me on this argument of Trilokinath not being applicable, then in which case, my lord, it should be given to those who have worked as civil judges, whether or not they are now in the direct recruitment category. Persons like me. I was a civil judge. I worked for several years as a civil judge. Today I have qualified for the direct recruitment exam. So now I'm a direct recruit. So if you are going to give that benefit on the basis that somebody who has that experience, who has worked,
That should also be given to you.
that should also be given to me, because the classification is based on this, that those who have that experience will turn out to be better judges. That is a benefit to them. Then that should be given to me as well, not only, my lord, to the promotees. That's my submission on that, my lord. Then, my lord, Justice Bagchi had asked about Jagannath. I just want to quickly distinguish that. That was only for pay scale, not for the purpose of giving any benefit for promotion.
Here also, they are not asking for promotion, only their consideration for a particular post in a cadre.
In a sense, it's a promotion. Your lordship has seen the rule. There is a rule prescribed as to how you are going to be promoted to senior scale and how you are, it is merit cum seniority. That is Rule 27 and Rule 27A. In the cadre, there are separate posts for which a promotion criteria is laid down.
But loosely used, but not a promotion in the sense of understanding by service to student.
Now, secondly, in that case, it was, as my understanding is, my lord, again, not based on source. In this case, it is based purely on source. You are proposing a distinction between civil judges and direct recruits only on the basis of their experience as civil judges.
You are supposed to conclude by 1 o'clock because.
Yes.
It will be unfair to them.
So therefore, my lord, that was my last submission, that Jagannath, in any case, Jagannath is 3 judges, your lordship is sitting in 5. And my lord, it may not be laying down the correct law if it were to say that no, even if it is relates to source, etc., it can be done. According to me, it can't. That's my humble submission.
Everybody has to conclude by 1 o'clock. So otherwise it will be unfair to them. We have granted this 1 day time.
I'm always the person who this is told to.
No. You should have timed it out because.
I'm following the sequence.
Oh,
There's a
what are
discipline to the
it?
sequence.
We had granted them 1 day, they finished in 1 day.
I'm only arguing.
We should have finished in 1 day, but the timings which you are allotted now.
My submission is in volume 2R4. 2R4, and I've had copies also.
Yes.
I have 3 broad submissions, 4 pages is what those submissions are. So I'll just immediately tell your lordships what they are. The first, my lords, your lordships have gone through the data points, you've seen the details, and I must say at the outset, we could not have had a fairer amicus. Mr. Bhatnagar is possibly the gold standard when it comes to that, in how fair he is in putting across submissions and putting across things which may not completely comport with the argument that he's going to make as well. So the amicus.
The data which he has given is based on the affidavits of the high courts.
Yes, of course. And I'm saying now that we have those, your lordships will recall that the first 2 orders which were passed in this matter, which are dated 17th September 25 and 7th October 25. I'm not reading it, but if your lordship were to see that, there were examples at that point which made one feel that, look, there is a complete imbalance in this. Now that some of the data has come, not all of it, but some of the data has come from the states, possibly not in the most ideal form, but they've put for last 5 years, they've shown with reference to principal district judges as well as district judges, etc. We find that that may not be entirely justified at a national level, clearly. There is,
Oh, yeah. We can quite appreciate in different states.
correct,
It is a different position.
correct, very different position. So now,
In Delhi,
yes,
the promoters are having a
Correct.
upper hand.
correct,
As
So-
far as Calcutta is concerned,
correct,
there appears to be an equilibrium balance.
correct. So,
50-50.
so
And
that.
some states, it is totally dominated by the,
Correct, correct. So-
by the direct.
So
There's
I-
no uniformity.
So because there has been that shift that we have found now from the initial orders which led to this constitution and this question going on, I believe that one of the major, there are two premises as far as I'm concerned, page 1, I've set it out. Two major premises that led to this very issue and the constitution bench looking at it. The first was that promotee judges are losing out on career progression. That may not be accurate. We have found that it could be both ways. So that,
It's a different situation in different states.
yes, it's a different situation. Exactly, which is why for a constitution bench to say that there is a underlying malaise, which is that promotee judges are losing out vis-a-vis direct recruit judges may not be an accurate premise to start with. I think that is accepted. Nobody is doubting that. Across the board, that is not.
There is also now another premise that in some states,
Yes,
that position exists.
Yeah.
And in some states,
it's the converse.
the direct recruits are at a disadvantage.
Correct, correct,
So
correct.
is it not more the reason that there has to be some uniform,
No, so Manoj,
uniformity to
There
be
is-
adopted in all the states so that
if, and I adopt Mr. Bhushan's submission on this, if we are supposed to look at it purely as a service dispute, saying that, look, direct recruits versus promotees, maybe there is something to be said about that. But Manoj, as a constitution bench, when your lordships are looking at the judiciary in this country, I would beg to differ and say, please don't look at it as a service dispute.
no, we are not
Please
looking
look
at
at
it, we are not, so please don't misunderstand it. We are not looking
Yes.
it as a service
Yes,
dispute.
but it
We-
becomes,
We are looking it with a larger objective of enhancing the efficiency of administration of justice
Correct.
in the entire country.
correct, correct. So if
That-
we have to look at it like that, let's consider what are the parameters being adopted for that purpose about efficiency of justice. Absolutely right. That's the only parameter, that's the only lens with which we must look at it. So if you're looking at efficiency of justice, is there any data that has come on record to suggest that promotee judges are better served at serving the ends of efficiency of justice as against direct recruit judges, or that direct recruit judges are better, or that a 1:1 ratio is necessary, which will help serve this? If we don't have any data, and to be honest, Manoj, I haven't found any being placed on record, that link doesn't exist. The link between the necessary ratios between direct recruits and promotees, the fact that one is better than the other, serving the ends of justice, I cannot find. In fact, unfortunately for me, what I can find is that the court that I practice in has 34 judges today, of whom not one is a promotee. So for me to come to that conclusion,
Court,
this court.
no promoting that.
So all 34 of your lordships.
That's begging the question.
No, so as far as I'm concerned, I find it frightfully efficient. But I don't know, would this picture have been different if there were 34 others? I can't answer that, Manoj. But I'm saying today,
Then,
this court doesn't have a data point as far as they are
the
concerned.
5 of us sitting this side
Yes, Manoj.
are having experience of 9 high courts.
That's true. That's exactly, that in fact supports with what,
Two chief justices who have come from the promotee. We've had two chief justices here who have come through the service route. Here.
so I'm saying,
And many judges, Justice Mudolkar,
Yes, sir.
Justice Palkar,
there's no doubt. But I'm saying,
In this court.
are we to presume?
therefore we are not going we are not basically going on a dispute between a direct and promotee.
Correct.
We are only trying to find out what should be the best system in order to enhance the efficiency of the administration of justice.
Yes, so this is a continuing effort. It's always going to be a continuing effort based on our
It has been
lived
continuous.
experiences.
Or
Yes,
All India judges has been doing it
correct.
continuously.
That's why it's been going on so long.
And it's a question of trial and errors.
Correct. So,
What this court found correct in 2002
yes,
was found to be required to be changed in 2010.
Yeah.
And after 15 years, this court again finds that it is.
that is true. That is true. And I mean, far be it for me to say, but whatever judgment comes from here, I'm sure there could be a revisiting based on
Yes, but could be.
further experiences we have after 5 or 10 years. So my only suggestion is this, because the constitution of 5 judges in this continuing exercise, I don't believe is going to be common. I think it's a rarity. It's the first time it's happened here. So if your lordships were to lay down any principle, that principle, I think, should be based on 2 things. One, that we have enough data and we have some material on the basis of which we believe that there is some problem that we need to address. I am fighting to see where that problem is. What is the problem here right now, today?
Because you have
existing-
practiced only in this court.
No. I don't see that as a problem. I don't see that as a problem. I've gone on record. I've gone on record volubly to say that the lack of women in the Supreme Court on the bench is a problem. I see that as a problem. The lack of promotees, I'm not seeing this as a problem. I'm not seeing it there. I'm not seeing it here. I don't see it anywhere. So if there is, there has to be data and material to start with. That's point one. Point two, if we look at it as far as the law is concerned, those three judgments, I'm sorry, I think Mr. Bhatnagar didn't have enough time to place that fully before your lordship, but those initial two, which are the ones which I've referred to at page 2 of my note, Mervyn Kutindo and Roshanlal Tandon, on facts, because I know, my lord, the Chief Justice had some misgiving about lawyers in this court only showing strands of
No, so I
paragraphs,
I
etc.
still hold that opinion.
Huh?
I still hold that opinion.
My lord, if when we fight with tight timelines like this, when we're given 20 minutes, very difficult for us to show the full facts and everything. But I'm just trying to tell you what the context is of these three judgments. So,
In the matters which have been argued for days and days,
yes,
also we have, at least both of us have,
correct. That is,
when we're sharing the bench, we have
That is-
seen the same thing.
that is correct. I hope I will not be guilty of that. So, Mervyn Kutindo and Roshanlal.
I make an attempt to change the opinion of others because I have hardly now any
No.
days left to change us.
These impressions shouldn't rest with, it pains me every time I hear judges of this court, including judges who come from the bar saying, Supreme Court lawyers, you do this or that. I believe that we have to hold up the highest standards of advocacy in this country. And if we are falling short, then we must correct ourselves. And I do not want your lordships to leave with the impression that we have not placed the full facts of cases before you. Mervyn Kutindo and Roshanlal Tandon are very squarely on the point that is sought to be addressed here, which is effectively of creating a cadre within a cadre, which is the way Justice Bagchi had put it on the first day. It is precisely that. In Kutindo's case, in both those cases, both the constitution benches had framed two issues. And in both those cases, they answered one issue in favor of the petitioners and the other issue against the petitioners. And in both those cases, the issue they answered in favor of the petitioners is the one that I'm relying on now. I'm just breaking it down quickly because I want to reduce my time so that others can argue. In Mervyn Kutindo, it was dealing with principal appraisers within the customs department. It is, and this may answer one of the questions that my Lord Justice Suryakant also put, roster, did it really arise in the background of reservation of SC, STs, OBCs to try and fit them all with some level of fairness? I have found, in fact, the first office memorandum, just to give copies. This is a 1959 office memorandum of the government, which dealt with, in fact, Burmese civil servants were brought into our civil service, etc. So with reference to all of them, they dealt with and introduced the roster. Subsequently, it became a 40-point roster, and that's the one that is dealt with in Indra Soni, Sabharwal, etc. as the one that has to be adopted. And it's not in the context of 1516 reservations. It's in the context, effectively, if your lordships will see, there's one paragraph from that I just wanted to read to your lordships, which is that in page 5, the explanatory memorandum at the end, just see General Principle 6. General Principle 6 at page 5, your lordships have that?
Yes, related
It's
seniority.
a roster should be maintained based on the reservation for direct recruitment and promotion in the recruitment rules. Where the reservation for each method is 50%, the roster will run as follows: 1 promotion, 2 direct recruitment, 3 promotion, 4 direct recruitment, and so on. Appointment should be made in accordance with the roster and seniority determined accordingly. Now, this is, and I'm not troubling your lordships further with this, but this is where the genesis of this roster idea and its implementation started thereafter. Now, this question came up in Mervyn Kutindo on roster specifically, and not once again in the context of reservations. They specifically said that we believe that roster causes discrimination and therefore please don't have roster. Mervyn Kutindo's case, it's there in my note. Your lordships may just note that this was the argument that was taken. And at page 5, I'll just read this out. It's from that volume which is in the footnote, volume 5A. 5A is where the judgment is. at the bottom of page 5, referring to this very circular which I've handed to your lordships, they say this brings us back to the circular of 1959. And the main question in that connection is the meaning to be assigned to the words seniority determined accordingly in the explanation to principle 6 relating to relative seniority of direct recruits and promotees. As we read these words, the plain meaning is that seniority as between direct recruits and promotees should be determined in accordance with the roster, which has also been specified, namely one promotee followed by one direct recruit and so on. Where therefore recruitment to a cadre is from two sources, namely direct recruits and promotees, and rotational system is in force, seniority has to be fixed as provided in the explanation by alternately fixing a promotee and a direct recruit in the seniority list. We do not see any violation of the principle of equality of opportunity enshrined in Article 16 by following the rotational system of fixing seniority in the cadre, half of which consists of direct recruits and the other half of promotees. Now, my lords, if your lordships were to come to page 7, which is the next page. So they say that there are two levels that they're looking at, the appraisers and the principal appraisers. In appraisers, they say there is no problem with having this kind of a process system. The second issue which they consider is its application when you have two sources of recruitment, one from promotion, the other from direct recruitment, which is exactly what we're saying here. That once you come into this cadre of direct district judges, there's no question of looking at what they were previously. So page 7 brings in the middle of the paragraph dealing with the second issue. This brings us to the question of principal appraisers. We are of opinion that the petitioners have a legitimate grievance in this respect. The source of recruitment of principal appraisers is one, namely from the grade of appraisers. Here, district judges. There is therefore no question of any quota being reserved from two sources in their cases. The rotational system cannot therefore apply when there is only one source of recruitment and not two sources of recruitment. In a case, therefore, where there is only one source of recruitment, the normal rule will apply, namely that a person promoted to a higher grade gets a seniority in that grade according to the date of promotion, subject always to his being found fit and being confirmed in the higher grade after the period of promotion is over. I'll just skip 2 lines. Insofar, therefore, as the respondent is doing what it calls restoration of seniority of direct recruits and appraisers grade when they are promoted to the principal appraisers grade, it is clearly denying equality of opportunity to appraisers, which is the only source of recruitment to the principal appraisers grade. There is only one source from which the principal appraisers are drawn, namely appraisers. The promotion being by selection and 5 years experience as the appraiser is the minimum qualification. This judgment, Mobin Kutindo, is followed squarely by the Constitution Bench again in Roshan Lal Tandon. And in Roshan Lal Tandon, they were dealing with examiners within the railway board. And there, my lords, it was dealing with promotion from grade D to grade C of train examiners. And they said, once again, you form one single class. That is at page 16 of the same volume is the findings regarding that. There again, 2 issues framed. This issue decided effectively in our favor, in our argument's favor. Triloki Nath was dealing with the engineering service of Jammu and Kashmir. Much has been placed on the reliance there. And there they were dealing with assistant engineers and whether they had a degree or a diploma. As Mr. Bhushan rightly said, this could come from either of the sources. So it really makes no difference. Secondly, Triloki Nath was referred to in Davinder Singh, the 7 judges bench. Davinder Singh is a judgment which had 6 separate judgments in it. One was a dissenting judgment of Justice Trivedi. The other, including my Lord Justice Nath, Justice Gawai, all were in the majority. But we have to read each of those judgments to make sure that what was said about Triloki Nath was accepted by the others. Justice Chandrachud, writing for Justice Mishra as well, makes the comment that Triloki Nath is a law and good law and the leading law on the proposition that once you are in a cadre, if you have to look at special educational qualifications, that could be a factor for the purpose that you're seeking to achieve. In Tandon, it was the Triloki Nath, it was the question of examiners having a specific skill and a qualification that was required for the purposes of the work that they had to do in Jammu and Kashmir. The proposition that is formulated by Chief Justice Chandrachud is not one that is at all found in any of the other judgments. In fact, my Lord Justice Gawai follows N.M. Thomas, which says that Triloki Nath does not apply. The paragraph is extracted where Triloki Nath does not apply to the facts of that case is specifically said. So To say that Davinder Singh, 7 judges bench, has followed and adopted Trilokinath is not a correct reading of ratios of judgments. That's not the way it goes. None of the other judgments agree with this on this proposition. Therefore, Davinder, if at all, is saying it as an obiter because it is not dealing with that issue. Davinder was looking at the Chinaya issue.
Davinder is basically dealing with sub-classification.
Subclassification. That's all it was. So this has no rationale and no connection with that at all. If at all, it's obiter to that extent. In any event, I don't think Triloki does any violence as far as we are concerned. Manoj, I have mentioned there are multiple options which are available, and your lordships have been responsible for ensuring that as far as any possible heartburn could be there. Because if, as far as the promotees are concerned, there is heartburn, as recently as in your recent constitution bench, your lordships have already addressed that. If you see page 1 of my note, I've extracted that paragraph. Just let me read that out to you in this Rajneesh versus Deepa delivered last month. Your lordship say at para 159, and if I can read that, it's extracted at page 1 of my note. Insofar as the contention regarding the heartburn amongst the judicial officers in a situation where a junior gets promoted before the senior is concerned, in our view, the said contention is without any merit. The in-service candidates, though junior, will have to compete before being selected with the advocates as also the seniors, who also will be qualified, and only meritorious candidates would be selected and appointed. If a person is meritorious and on account of merit and merit alone gets selected directly as a district judge, there can be no question of heartburn for those who are not as meritorious as persons selected. Keeping that in mind, my lords, now consider the 4 measures that are in place as far as these promotees are concerned. The first is that there's a 25% quota LDC exam which is available, so they can participate and speed up the process. The second is the 40-point roster system. There's a page 3 of my note I've listed it. 40-point roster system. So the roster, if it's properly applied, if it's not properly applied, there's a problem. My suggestion, my lords, is after this judgment is done, please just supervise it, just like you've done in Prakash Singh with the police reforms, where all the states have to come and show that they are towing the line. In terms of Article 144 of the Constitution, let the states and the high courts come here and show what they're doing on the roster. If that's not being done, if LDC is not being conducted, they have to answer to it because there's a direction of this court. They have to follow it. The third is where you have reduced the minimum experience required for LDC from 10 to 7 years. Fourth, now in Rajneesh, you have opened it up for them to participate. So today, in the 50%, in the 25%, and in the 25%, they are available. They have all 3 avenues available to them. The direct recruits have only the 25%. They have all 3. All 100% is available to them. You could have a situation where all 100% are full of promotees. You could have that. It's possible. And my lords, the question that I believe should be framed is the one at 3.2. When we look at what is the issue here, the question is not, do both promotees and direct recruits have equal opportunities to seniority in the district judge cadre? The question is the service of justice premised on the mode of recruitment of judges? It's, in my view, my lords, it's the second question that's the one that has to be looked at. Finally, my lord, just this one judgment that your lordships drew our attention to, which is there in the amicus, is on Jagannath. The distinction is that in Jagannath, they were a single cadre to start with. The cadre was then split up. They were split up as they were known as compositors, and the compositors had clerical work to do based on skills. And they said that the compositors were splitting into grade 1 and grade 2. And those who were put in grade 2 were put in grade 2 because they had lesser length of service. So those people objected, saying, when you're splitting us up, you can't do that because we have the same levels of same type of experience. They said, no, we're looking at skill sets and therefore this division is permissible. That's not the question that arises here. We didn't start as a common pool. We became a common pool, and once we are a common pool, you can't split us up. So it's the exact converse. I'm grateful, Melissa. I'm most grateful.
With your lordship's permission,
Yes.
I'd like to appear for the direct recruits of the UP Judicial Services Board. And my IA number is 269748 of 2025. Lord. And my written submissions are in volume 2, R.3, Lord. R.3, Lord. And page number 6 of my lords has that, my lord. Honorable
Yes.
Chief Justice, my lord. My lord, I won't trouble too much because there are the 2 other people to follow. But I can only say this, Lord, I'm looking at the watch. My Lord, I can only say this, that insofar as this side is concerned, the common consensus, and your lordships have heard it again and again, is that, my Lord, the roster system is a good system. Whether your lordships finally accept it or not is another aspect. The second aspect which emerges, my Lord, after hearing submissions of counsel from this side and that side is, sometimes it breaks. And as my Lord, Justice Suryakant and Honorable Chief Justice said, when it breaks, what happens? Lord, your lordships have repeatedly said, if it becomes impractical, then you need not follow the roster system. Insofar as UP is concerned, my Lord, the figures, my Lord, in fact, if your lordship would see, for your lordship's convenience, at page 10, it's only for your lordship's convenience, my Lord. We've taken the data from the amicus's brief, my Lord. And your lordship would see 5.1. So Bhakti has it now.
Yes.
Lord, if your lordship would see serial numbers in that first table, 1 to 9, except for Rajasthan and Arunachal Pradesh, in every case, Pramoti Judge, they are more, sufficiently more. My Lord Justice Suryakant. Similarly, my Lord, 5.2, again, the ratio is higher. And at page 12 again, my Lord, except for Bihar and Himachal, in fact, Himachal, it's very close, my Lord. Serial number 11, 4 and 3. Bihar, there is this huge dissonance, so to say, my Lord. 86 and 5, 5 promotees, 8 direct recruits. But rest, it seems, the promotees have a healthy number. In fact, my Lord, in Kerala, Justice Chandran would note that, and if I'm not wrong, please correct me, my Lord. At the foot of that table at page 12, it says, my Lord, para 7 of the affidavit, and this is from the affidavit, of the 48 principal district judges of the last 5 years, 30 are promotee. My Lord has it, Lord. Page 12 at the foot of the page, Lord. 30 are promotees, my Lord, these are High Court judges, and 8 are direct recruits. So there is a healthy number in the Constitutional Court also, my Lord. Of course, my Lord, later on, as I think the position today is out of 42, it is now 10 directly recruited and 5 promotee judges. Now, insofar as Allahabad is concerned, my Lord, and that's why I want my lords to see that judgment. When it breaks down, what happens, my Lord? When your lordships passed the judgment in 2002, the AIJA judgment, my Lord, your lordship said, go via the roster system. In Allahabad, my Lord, till 2007, my Lord, no corrective measures were taken. And in 2009, the rules were amended. With the result, my Lord, in 2007 and 9, my Lord, there were no vacancies filled and it broke down, my Lord. Your lordships in Allahabad High Court versus State of UP, my Lord, and para 12, if your lordship would see, not para 11 is a citation of my written submissions. It is important, my Lord, to keep this judgment in mind because it covers a whole lot of precedents. And in paragraph 12, my Lord, the court frames 2 questions. Page 15 is paragraph 30, my Lord. I would just want to read that very quickly, my Lord. With regard to the quota rule, page 15, my Lord, para 30 of the judgment, of the 2018 judgment, which applied specifically to the Allahabad High Court. With regard to the quota rule, there is no doubt that there is mandatory requirement of the rules. Lord, my Lord has it.
Yes.
The said requirement was, however, to be seen in peculiar fact situation. The issue of determination of vacancies was embroiled in continuous litigation. This was between 2002 and 2007. The quota rule could not be applied in the absence of determination of vacancies. The suitability test, though validly laid down, could not be held till 2008 for reasons already noted. No promotion could be given in the absence of suitability test. Lord, this was for the promotees, because under 2002 judgment, they had to have a suitability test. And then, my Lord, your lordships go on to say the rule provided for seniority of the promotees to be fixed from the date of availability of vacancies, but such seniority could also not be given in the present fact situation. If the rule is applied, it will work serious prejudice to the promotees. Thus, the rules will have to be given a pragmatic interpretation as laid down by this court, not in an earlier judgment. It's a well-known direct recruit case. If it becomes impractical to act upon the rule fixing quota from two sources, it is no use insisting that the authority must be given effect to such rule. Every effort has to be made to respect a rule, but it's not feasible to enforce it. The rule has to be given practical interpretation. Thus, interference by the High Court with the seniority given to the promotees above the direct recruits without following the rotation principle cannot be sustained. Now, my lord, this judgment considered previous precedents, which is why, my lord, I'm not laboring that point. O.B. Kirk, Shrikant Tripathi, and Ashok Pal Singh. My lord, the sum, and in Randhir, my lord, in 2021, the court, my lord, sustained this principle. That is, you have to go by the roster system. If it breaks down, then you have to file a practical solution. Now, my lord, in sum and substance, therefore, my lord, as I started by saying, that the roster system is not perfect. Lord, it's something like democracy, we say, my lord. It's not the best system, but the others may be worse. One. Two, my lord, since your lordships have taken, and I don't want to repeat, my lord, three major steps, which is entry.
That has been argued at least.
My lord,
by half a dozen
why?
times.
No, correct. I'm sorry, my lord. I'll just conclude by one thing. My lord, why did the entry level experience come? And this is what I want my lord, the Chief Justice, to consider. My lord, your lordship knows that there is the NCMS, the National Court Management System. My lord, the committee called for empirical data, and your lordships noticed that majority of the High Court said that there has to be some experience. The question was 1, 2, or 3 years. Some said 2 years because they said there is judicial training. Some said 3. Ultimately, your lordships decided one way or the other, 3 years. The other is about LDC quota, and then the Rajneesh, my lord. My lord, my respectful submission is, my lord, there has to be impact assessment. 1. 2, my lord, an observation that fell from one of my law lords, my lord, is diversity is an important aspect, my lord. You cannot just say that I must have only in.
Nobody is against diversity.
Yes, my lord.
On the contrary,
Ma-
the argument is that there has to be representation to all.
I'm deeply obliged. My lord, I'm deeply obliged. I'm only saying,
That-
therefore,
Inclusiveness.
no, I'm just trying to link it to my first submission, my lord. Therefore, if the system is not broken, it's my respectful submission. Lord, please continue with it. See how it plays out. Your initiatives, my lord, the Chief Justice, under your leadership, my lord, those 3 judgments are written. Please see how it works out. And as my lord, the saying goes,
That was
my lord, if
the-
it's not broken, let's not try and fix it. Because we
That
try
was
and fix
the
something.
advanced by the learned Attorney General yesterday
Yes, my lord.
by replying to the validity argument which challenge the validity of the rules, the tribunal's rules. That the system should be permitted to work
Yes.
for some time, and then the court should decide about the validity of that.
Yes, sometimes, my lord, it is right. Even for law, we constantly say, my lord, the last thing that I want to say, sir, an observation which your lords made, my lord, let's have guidelines. My lord, the difficulty with guidelines is, and this is some amount of, any word from my lords, my lord, no Chief Justice is going to cross it, and should not, because there has to be judicial hierarchy, my lord. Once your lordships even makes an observation, lord, I don't think the Chief Justices will be able to cross that. So therefore, the danger in saying that we'll say guidelines with discretion, Lord, may not work. That's my respectful submission. Your lordship may consider.
Adopting Mr. Rakesh Dwivedi's argument and
Sir.
for doctoring.
Sorry, my lord.
You are adopting his argument, Mr. Dwivedi's arguments.
No, I'm not.
Hands off.
No, my lord. I am not going that far. I am only saying, my lord, in a judicial hierarchy, and correctly, my lord, if your lordship says something, they ought not to. It will bind them. They will not be able to use discretion. How your lordships are going to mold it is up to my lords. My lord.
Thank you.
Yes.
My lords, I appear for the direct recruiting judges from Maharashtra, state of Maharashtra, my lords. My submission is threefold, and quickly I'll do it in 12 minutes, my lords. Number one, what my lords have always encouraged is an equality of opportunity. When right from 2002, when my lords had introduced LDC, now Shetty Commission, at that point of time, the only way out was promotion. So they suggested one was weightage and another was LDC. What my lords did was came up with a clean scheme. Paragraph 27 to 30 in my humble submission, my lords, is a complete scheme. 29 may not be just taken independently. 27, 28, 29, and 30 is where your lordship first introduced LDC for the purposes of granting equal opportunity, a better opportunity to those who otherwise were not able to have an accelerated growth in their career progression. And therefore, in that context, my lords, what your lordship, I'll just read 3 lines, my lords, of paragraph 27. What my lords had indicated was, furthermore, there should also be an incentive amongst the relatively junior and other officers to improve and to compete with each other so as to excel and get quicker promotion. So my lords, number one had taken this into consideration for the purposes of benefits of those junior officers who never had the occasion of otherwise moving forward in a fast track. These 3 lines, my lords, have repeatedly been followed by your lordships in 2022, 2025, and the recent in Rajneesh as well. Then, my lords, in paragraph 29, my lords created a link between these two. I'll just read again a few lines, my lords. As a result of the decision today, there will, in a way, be 3 ways of recruitment of higher judicial service. The quota of promotion, which we have prescribed, is 50% by following the principle, merit cum seniority, 25% strictly on merit by limited departmental competitive examination, and 25% by direct recruitment. Experience has also shown that the least amount of litigation in the country where quota is in.
That is already.
Yes, my lord. So I'm connecting is all this, my lords, that the roster system your lordship had adopted, keeping in mind your lordship is also offering an alternative of LDCE at that point of time, which today, my lords, with your lordship's recent judgment, has now additional district judges directly in Rajneesh. So my submission, my lords, is really, my lords have always been encouraging meritorious candidates who now have the option. Now, with the informed decision, somebody takes an option that either I'll continue as a service and go the promotion route, or I take an informed decision. My lords, I understand. I'm only saying is, my lords, 2 applicants, my lords, before lordship in this application, they had, considering this particular judgment of 2002, my lords, they had resigned as civil judges, practiced, and thereafter they had then given the exam for district judge. So there are situations, my lords, where people have actually made a conscious choice in terms of what is available and then move forward. So my lords, that is the first submission, my lords.
Legitimate expectation and problem.
Lordship, please. My lords, as regards the Shetty report, my lords, what my learned amicus had been relying on was the age group and the age gap. My submission, my lords, is the Shetty Commission data is today 2.5 decades old. And therefore, my lords may consider not relying upon that data for the purposes of laying down a policy for the next decade.
We are not relying on that. We are relying on the data which is supplied by the learned.
I'm grateful, my lords. So in that basis, my lords, may I just submit for lordship's consideration? My lords, I've just compiled the data which was available on the record to my best of my capacity, my lords, in terms of what is the age difference, which is really happening today in terms of what it was.
You are on the basis of the affidavits of the.
My lords, I have taken that affidavits, my lords, only to indicate your lordships, and I put that in the annexure, that wherever the data is available, my lords, and it is part of my written submissions, out of 11 states where the data of 99 and the data of 25 is available, my lords, in 8 states, the age difference is actually reduced. So my only submission is, my lords, considering that your lordships had introduced LDCE in 2002, and now in Rajneesh that your lordship has created another third possibility, the possibility of having the age difference being reduced in the long term is something which is quite would be there, my lords, and therefore lordship may consider having and continuing with this roster system for the purposes of this seniority. Also, my lords, there was one line where one word in terms of age changes, my lords. Again, a calculation which we have done, my lords, in terms of what after Rajneesh, what would happen. So far as civil judge is concerned, my lords, he would at least by promotion, probably if we take 23 years as the age of entry as a civil judge, my lords, he will probably require 13 years to reach the age of district judge. But my lords, if the civil judge can become eventually district judge through the LDC route, he would have probably only a minimum of 10 years would be required. Similarly, my lords, an in-service civil judge.
The calculations have been given by DFR.
My lords, so I'm just saying, my lords, today the age gap is not only reduced in terms of whatever data is moved on from Shetty Commission today, whatever is available on record, my lords. The possibility of actually having some kind of a parity between these two groups is quite high, considering that your lordships have now, with this judgment in Rajneesh and in the judgment of IJA in 2025 and only 2002, my lords have ensured that there are multiple options available to these in-service candidates as well. And therefore, to that extent, my lords, my submission would be that so far as roster system is concerned, that may be continued. Also, my lords, just one last word. The gradation list which has been relied upon, my lords, the lordship has always seen. The gradation list may differ from year to year in a state, and it may not even be uniform between different states, my lords. And the reason would be in terms of that the lordship's directions and Mazhar Malik may not have been followed to the requirement in terms of what the period of and the requirement of recruitment policy is. If that is tend to hold, my lords, probably there is also a possibility that this entire roster system would not require to be changed, my lords. That is my limited assumption. Lordship, great.
Yes,
Your Lordships, I appear in this IA number 258354, filed on behalf of the direct recruitees of the Rajasthan State Judicial Service. My Lord, I have five-fold submissions. In a nutshell, I know the time constraint and because Lordship has fixed five. My Lord, the first thing I'll submit with your Lordship is, my Lord, the amicus has raised grievance that, my Lord, those people who come from the civil judge cadre, they don't reach up to the, my Lord, level of principal district judge. My Lord, my first submission is, my Lord, principal district judge is a posting. It's not a cadre, my Lord.
that's already argued.
No, this is what I'm saying, my Lord. Because, my Lord, now all high courts, my Lord, under Article 233, my Lord, they have got power of not only recruitment, but a posting also. So, my Lord, anybody who's posted as, my Lord, district judge, my Lord, that depends on not only on seniority, on acumen and other considerations which High Court feels, my Lord. My Lord, because all the district judges, including principal DJ, my Lord, they discharge the same judicial function. It is only administrative, my Lord, powers which are given to principal district judge in the maybe of, my Lord, the transfer of staff or, my Lord, giving particular cases. So, my Lord, what I'm saying, that this functional responsibility of principal, my Lord, district judge will not definitely confer him with any extra judicial power by which he can say that I have been deprived from this assignment. So, my Lord, my first submission would be that Lordship has to consider whether this grievance can be raised by people who have been inducted in service, knowing fully well that we have joined the ladder as a civil judge at a young age. And, my Lord, this has not been projected before this court that, my Lord, these people, first they become senior civil judge, they become ACJM, then they become CJM, then they become ADJ. My Lord, they are going in the ladder and ultimately, my Lord, they come to the cadre of district judge. So, my Lord, to say this by amicus that we have been deprived of this principal DJ, my Lord, with utmost, my Lord, humility at my command, I'll say, my Lord, this is absolutely unfounded. This is adding a new, my Lord, absolutely angle to the service jurisprudence was saying that for principal DJ, there has to be some quota or reservation. My Lord, my second submission would be, my Lord, that this quota rota system which has been introduced by virtue of judgment of this court, my Lord, that has been followed by most of the high courts. My Lord, I know about Rajasthan, I got rules also I have placed on record. My Lord, now there is a system of assigning senior to them that first three slot will go to the promotees. The fourth will go to direct duty. My Lord, this ensures that, my Lord, these promotees, they get their due and the direct duties do not march over these people, my Lord. My Lord, now third thing, the one, my Lord, fear which was alleged by Ms. Makhiza probably, my Lord, she said that those people by merit, now because now these, my Lord, people can come all three streams by judgment by lordships, my Lord. I'll not repeat that. So, my Lord, now, once they come in limited competitive
We have already, when she was arguing, we have already openly said what was in our mind with regard to our argument.
No, no, Lord.
Not,
No, what I'm saying, my Lord, one aspect has not been pointed out. My Lord, these limited competitive examination people who appear, civil judges, how their seniority will be reckoned. It was said that in the lower cadre, whatever seniority was there, their merit diminishes, my Lord. My Lord, there is a judgment of this court. My Lord, this is Dinesh Kumar Gupta versus High Court of Rajasthan, my Lord. My Lord, this is 2020, volume 19, STC page 604. My Lord, I had requested the court master to give it because I couldn't get the first to stop. This answers the, my Lord, this particular fear of these people who come in the, my Lord, competitive examination. My Lord, I'll refer to the issue and then I'll give the answer to that which has been given by this court. My Lord, there are issues which are at page 607. Please turn to page 607, my Lord. Directly to the issue, my Lord. At 607, my Lord, Roman 4 is the issue. Lord, you have that. Whether the inter-C placement of candidates selected to the cadre of district judge in the state through limited competitive examination in the seniority list must be based on their merit in the state examination, or should it be based on their initial seniority in the erstwhile cadre. My lord, now please turn to the answer which has been given in this case, my lord. I'll refer to para 49 and 50, my lord. The lordship would find para 49, my lord, at page 666, 666, my lord. Please turn to my lord, para 49 and 50. Lord, para 49 starts.
Yes.
My lord, I see behind you, your lordship, my lord. Can I continue, my lord? I'll need, my lord, 10 minutes.
We can't be unfair to them also. We have given you half an hour more than what we had given to them.
Take it 2 minutes, my lord.
So,
Give me 5 minutes more, my lord.
because there are.
I think two and three are more left from our side.
Mr. Singh is also there.
Mr. Sanghi is there.
And I'm from Madhya Pradesh, my lord. I'll not take more than 10 minutes.
No, not 10 minutes. We'll
Five-
grant
five-
all of you 5 minutes each.
All right, my lord. Yes, my lord.
So I will grant you 20 minutes and about half an hour to the Senate amicus.
Please, very well. I'll take less than that, but whatever.
Yes. If Mr. Dwivedi wants to add anything.
Let's take 2 minutes after the mic.
But follow the timelines.
Not after the break, my lord.
After at 2 o'clock,
Not
you 5 minutes.
Not.
Not. Yes, Mr. Bhatt.
My lord, to allow the peers of, my lord, limited competitive examination candidates. My lord, this court has answered.
No, we are not on that. We are not going to go into.
No, what I'm saying, my lord, that this issue that now recently your lordship have also decided, my lord, that the judgment Rajneesh, that these people will also have entry in direct recruitment quota. So, my lord, this law laid down by this court, my lord, takes care of now both the issues, that whatever seniority they had in the earlier cadre, that goes, and whatever merit they had in the competitive examination, they'll get their placement, my lord. So, my lord, my submission is that, my lord, to recognize the merit of these civil judges, there's enough care which has been taken by this court so far, my lord. And, my lord, ultimately, my lord, once they come in the cadre, my lord, then they cannot say that we should have a separate quota. My lord, that's my second submission. My lord, my third submission is, my lord, these people who come from, my lord, JMFC, my lord, as I have filed with my IA, my lord, in Rajasthan, there are 12, my lord, honorable judges who have been elevated to the bench. My lord, out of 12, 11 are from this JMFC. Only one honorable judge has come from other state. He was direct recruiting. Mr. Munal Lakshman probably. So, my lord, now to say this, that they have been sufferer because of this is also incorrect. My lord, I also filed a list, my lord, where in last 10 years, there have been 287 postings as a principal district judge in Rajasthan. My lord, these people are 260, they are 227. Only 60 direct recruits have come. In last, my lord, 10, 12, 15 years rather, from 10 onwards. That list is there, my lord, I have filed it as Annexure R2 in a volume, this thing. Now, so, my lord, to say this, that it has been a cause of heartburning or it has been a cause of loss after joining as a civil judge, my lord, this is absolutely unfounded. My lord, my next submission is that the prayer which is being made by the amicus is about witness to be given. My lord, that has already been turned down by the, my lord, this court. I'm not repeating that, my lord. My lord, last but
You are
not
not
the least.
repeating, you are saying that you are not repeating, but you are doing the same thing.
No, my lord. In one sentence, I completed.
Okay.
My lord, last but not the least. My lord, entire application which is filed by the other side. My lord, that's the aspirations.
Not by other side, by an amicus.
Amicus, my lord. Right now, because they are sitting on this side, I'm saying. My lord, they say aspirations of these people have been, my lord, affected, diluted, taken away. My lord, this is absolutely a wrong proposition which has been put forward. My lord, anybody who joins a judicial service, my lord, this court consistently held, they are not like a government service. The government servant, my lord, might have some aspirations in a cadre that I have to go there and here. My lord, anybody who joins as a magistrate or, my lord, to the top court of this court, my lord, it's only sacrifice, it's only, my lord, service to the society, and that is the object of any judicial officer. There are no frills attached. There are no, my lord, power attached to this job. It is only sacrifice, my lord. Either direct recruits come, they have a lucrative practice, they have worked at the bar for a very long time, and my lord, even the magistrate who joins, he also has a hope that in the ladder, I'll be rendering my service. So, my lord, after joining the service, if somebody takes a view that no, my chances are, my lord, taken away by such a system by the employer, my lord, that cannot be a basis to claim aspiration. My lord, I have to support that, my lord, why aspirations are limitless. My lord, I'll drive your lordship's attention to one application which has been filed in this court, my lord, by these all India, my lord, judges. Your lordship may have this IA. What are they claiming now? My lord, this IA, your lordship have this all India Judges Association, there's one IA filed. My lord, there they say now, not only reservation in quota for principal district judge, for high court also, there should be separate quota.
We are only considering the.
My lord, but what I'm saying, my lord,
Considering the item filed by the learned amicus.
I know, my lord, but there's a IA which says that.
We are not considering that IA.
My lord, I hypothetically,
Anybody argued that IA?
no, my lord, I don't.
Why not
Tomorrow,
on it?
what I'm saying, my lord, these aspirations have no limit.
Yes, anyway, Mr. God, thank you, yes.
My lord, one last, my lord, last submission, my lord. My lord, ultimately, this court has time and again said that if you join a government job, you can get 2 promotions. That is the law, my lord, which has been developed right from Raghunath Prasad Singh. This is 1988 supplementary STC page 519. My lord, the judgment is a 2-paragraph, my lord, which is very relevant. Why this is necessary promotion, my lord? As I said, my lord, these people who join as civil judges, they at least get 4 promotions in their life, my lord. It's not that they are stagnating. It is only, my lord, comparing with these other people, my lord, that is causing a problem. So lordship may have just look at this judgment. One paragraph I'll read, and lordship may have just look at this. Of course, my lord, it was a case of, my lord, police organization in Bihar. the person who came to this court, my lord, he did not have any chance because options were invited and he did not want that he should get an option and he should get, my lord, promotion. There was no promotion avenue. So, my lord, this court, my lord, in para 4, lordship, just 4 lines I'll read before lordship. My lord, para 4. Before we part with the appeal, we would like to take notice of another aspect. In course of hearing of the appeal, to a query made by the learned counsel for the appellant indicated the reason as to why the appellant was anxious to switch over to the general cadre. He relied upon 2 or 3 communications which are part of the record, where it has been indicated that there is no promotion opportunity available in the wireless organization. Reasonable promotional opportunities should be available in every wing of public service. That generates efficiency in service and fosters the appropriate attitude to grow for achieving excellence in service. In the absence of promotional aspects, like service is bound to degenerate and stagnation kills the desire to serve properly. We therefore direct the state of Bihar to provide at least 2 promotional. My lord, the judgment has been consistently followed. And as I, my lord, made a request.
Applicable here.
My lord, why I'm saying?
Yes, thank you. Yes, next, please.
Thank you, my lord. Obliged.
Please, Your Lordship. Lord, I'm the second last batsman in the last over.
Yes.
So whatever I have to do is in just
Not second last, third last.
third last, my Lord. But I'm in the last over in any case, my Lord. My Lord, I'm appearing.
You already argued yesterday before a different combination.
Yes, but that was, my Lord, relating to the amendment, my Lord. I have the notification. Now I'm here to meet the submissions of the learned amicus, my Lord. My Lord, since only Your Lordships and Justice Chandran were there, I may inform, my Lord, in my written submission, I've made a mention of it, that while this matter is pending here, the state of Tamil Nadu has come out with a notification amending Rule 8 of the relevant rules, my Lord, on 7th of October. And what they've done is that they have actually vertically trifurcated the cadre of district judges by saying that there'll be different seniority lists. So, my Lord, that has been put to challenge. Your Lordships are going to examine. Your Lordships have issued notice on that. My Lord, my submission, my Lord, I've made a written submission. I'll not read it because it will take time. I don't have time for that, my Lord. So I'm just touching upon the points, and I have just 2 paragraphs to show from 2 judgments and 1 suggestion which I have, my Lord, as a counsel of Your Lordship's court, my Lord, not as appearing for a party, my Lord. My Lord, so there are 3 sources of recruitment, my Lord. Your Lordship is aware, my Lord, that once from different sources, recruitments are made and they are merged into one cadre, then, my Lord, the birthmark is lost. That is the well-settled position, my Lord. May I just read 1 paragraph in that regard, my Lord? This is from Bhatnagar's case. This is State of Punjab versus R.N. Bhatnagar, 1999, 2 SCC 330. At page 340, my Lord, I wish to read. May I read, my Lord?
Yes.
Requisition here.
Huh? May I read slowly, my Lord?
Yes, you can.
Yes, my Lord. Yes. Yes. It says, on the contrary, it is a rule of recruitment from 2 different sources, namely in case of Professor Carden's cadre, 75% of the posts has to be filled by promotion, while 25% by direct recruitment. These 2 sources of recruitment permit departmental promotees and direct recruits from the open market to get absorbed in the cadre. They merely serve as 2 entry points for the cadre. Rule 9 deals with reservation of appointment for the post of to the post of professor and does not deal with reservation of post of professor for any special class or category of candidates. It is well settled that once recruitment is made from 2 sources, that is departmental promotees and direct recruitment from the open market, and once the candidates concerned enter into any cadre through entry point reserved for them, they get fused and blended into one single cadre and their birthmarks get obliterated. In this connection, we may usefully refer to the Constitution Bench judgment of this court, my Lord, in Trilokinath Hosa. Justice Chandrachud, as his Lordship was then was, speaking for the Constitution Bench, while dealing with the recruitment to a cadre from two sources, namely direct recruits and promotees, in the light of the earlier judgment of this court in Roshan Lal Tandon, made the following observations. The key words of the judgment are: the recruitment from both the sources to grade D were integrated into one class, and no discrimination could thereafter be made in favor of recruits from one source as against the recruits from the other source in the matter of promotion to grade C. Lord, page 341, I'm reading at the top. By this was meant that in the matter of promotional opportunities to grade C, no discrimination could be made between promotees and direct recruits by reference to the source.
That is already been argued by everyone.
Yes, my lord. So that is the position, settled position in law. In, my lord, in B.S. Mathur, now what is going to happen if these submission of the-
All points have been argued, so we would appreciate that you say that you have some suggestion to be given.
Very well, I'll first give your lordship the suggestion. My lord, the real problem, which this submission has been advanced, the real problem is occurring because of the bunching which is taking place.
You also have the experience of 2 high courts.
My lord, that's what I'm saying, my lord. In case recruitments are made as per the roster year after year, as your lordships have already directed Malik Mazhar Sultan, then this problem will not arise because there would be proportionate representation for each class and they would be at the same level. What is happening is this bunching is taking place because, my lord, let's say for 5 years, recruitment is not made. Let's say, my lord, just to take an example, 2010, there are, let's say, 10 vacancies of direct recruits as per the roster. The recruitment does not take place till 2015 when this number is swelled to, let's say, 20 or 30. Now, what happens is that in 2015, when the recruitment is done, people who are eligible in 2015, that is those who are 35 plus in 2015, they occupy positions which were available in 2010 also. They may not be eligible in 2010. If supposing the examination were to be held in 2010, they may not be eligible. But when in 2015 they compete, they are competing for all the posts. My suggestion as a counsel is, my lord, that a distinction could be made that people who become, the eligibility should be determined according to the year in which the vacancy arises. If that is done, then a lot of this problem will be solved. Real problem, my lord, as the learned amicus argued, the problem is of age. All this problem about representation is arising because the age at which the direct recruits come is generally considered as lower when compared to the promotees coming into the cadre. Therefore, they retire, my lord, they fall by the side and the direct recruits continue. That is the real problem. So this could be met if the vacancy of a particular year, in respect of that, the eligibility is determined according to the age on the date of that particular year. So that is my suggestion, my lord. And your lordship, I will not take further time, my lord. B.S. Mathur, your lordships have already seen. And my lord, I only want to say that direct recruits, after all, this is, my lord, induction of fresh blood. That is the whole purpose. Otherwise, my lord, one can...
That's what 2002 judgment also says.
So, my lord, otherwise there is no need. One can do away with this cadre completely. So, it cannot be that they are put to such a disadvantage that this incentive is lost and good candidates don't appear in that examination. And with all the factors, my lord, your lordship's judgment in this year's judgment, my lord, 2025, the LDC age being reduced, in my very humble submission, my lord, your lordship should wait. And for example, in 13 states, my lord, in the country, there is no disparity, my lord. In Tamil Nadu particularly, my lord, I have given those figures, my lord. The position is that there is more than adequate representation for the promotee judges at the level of the principal district judges. They are more in number. That is because probably the recruitment took place, and recruitment of direct recruits, the rules came in 2007. The recruitments happened only 4 times from 2007 till now. That is the position. So in my humble submission, your lordships may not take any steps at present, my lord. Your lordship should allow the system to work and for it to be reviewed maybe 10 years later in case there is a need, which I don't think will arise because with the steps which have already been taken, this disparity will not be there. Of course, Mazhar Malik Sultan should be strictly ensured, should be strictly implemented, my lord. If that happens, the problem will vanish, my lord. There would be no such grievance left. That's my submission.
Thank you. Yes, Mr. Gupta.
Yes, I am representing direct recruits from the state of Madhya Pradesh, my lord, the higher judicial service officials. First of all, my lords, I'll quote certain statistics before going to the submissions, my lords. My submission would be that in the state of Madhya Pradesh, the situation is diametrically opposite to, my lords, what is the situation which has been quoted as an example from Maharashtra, Gujarat, Bombay or Gujarat, my lords, in the application moved by the amicus. Now, my lords, I'll just take my written submissions, my lords, are volume 2, R4. I have culled out the facts and figures from the counter affidavits of the various states, my lords. First, I'll point out the situation in Madhya Pradesh. Lords, before that, 2002, my lords, the 3-judge bench in this case directed that rota quota system must be adopted, my lord, by amending the rules suitably. The roster point system, R.K. Sabharwal. Till 2018, my lords, for 16 years, the rules were not amended. The seniority was determined on the basis of continuous officiation and date of joining, my lords. So 50% promotees, continuous officiation, and date of joining if the vacancy year was the same, my lord. It was 2018, that is after our batch joined, my lords, that 2018 for the first time roster point system has been introduced, my lords. Now in our case, so what happened is something very startling, my lords. May just see WS2, which is page 59 of the written submissions. I have given certain dates. We are giving these figures, my lords, not just to highlight, my lord, that it is not a situation pan-India. All that a problem which may be existing in 2 or 3 states may not be telescoped for the whole nation. Is my submission. 59, my lords, page volume 2, R4, 59. WS2, my lord, there is a table. That is before, my lords. There are 2 paginations. One is our pagination and the other is pagination of the written submissions. Now, my lords, what happened is 2017, I am representing the 13-14 officers from the 2017 batch, my lords. The advertisement for direct recruits was issued in March 2017, the vacancy advertisement. Both the 50% and 25% LDC was June 2017. The results were declared in August and September 2016. Ours were declared in October. The date of joining of the previous 2, despite our vacancy 3 months prior, my lords, the date of joining, because the rules were date of joining and continuous officiation, the date of joining of ours is 5-6 months after the 50% and the 25%. So what has happened is, my lords, by virtue of these rules, en bloc, all these direct recruits who were selected, en bloc in the gradation list, they have been pushed below these 75%, despite the fact, admittedly, when our vacancy was before. My lords, the other day, my learned senior, Mr. Patwali, also highlighted the same problem with respect to Delhi. So, my lords, why this has happened? This has happened because non-implementation of the rota quota system. If this has been implemented and efficiently, my lords, it would have been made effective, my lords, perhaps this problem would not have arisen. R.K. Sabharwal says, my lords, it is premised on the cadre strength on a running year basis.
But you are arguing before us. Now you want us to upset the seniority.
No, my lords, I'm not saying, I'm not pointing out. I am just pointing out, my lords, a state that it is not the situation pan-India. What has been projected, my lords, in the application, my lords, which has been referred to the constitution page. Today, what I'm trying to point out is.
We keep on repeating.
Yes,
claims of a particular high court or a set of officers, we are not going to consider.
Yes, I'm not seeking that either, my lords, with due respect. It's just, my lords, that if the roster quota system is implemented, which is being done from 2000, the other thing.
Can be that rota and quota is one of the most acceptable principle to be followed.
I mean,
that's a general argument you can make.
In all fairness, I'll use the word. It's amongst all the other bad systems, it's the lesser bad. I would say.
You yourself be saying that in Madhya Pradesh High Court.
2018 it was introduced.
Matter ends then.
Yes, now, my lord, matter doesn't end.
You are wanting us to apply it retrospectively to your matter.
I am coming to my next submission. Now, my lord, despite rota quota system being introduced in Madhya Pradesh, to every year, my lords, 50%, 25% examinations are happening, my lords. But for the direct recruit, my lords, 23, 24 and 25, we are at the end of 25. 3 years, my lords, this examination has not happened. So what is the inevitable outcome, my lords, is despite implementation of rota quota,
inevitably it will break down. It will break down by virtue of a statutory provision, my lords, which has been introduced in Madhya Pradesh High Court rules, HJS rules, my lord, that where for 2 years the vacancy doesn't get filled up, it has to get surrendered. So, my lords, my submission is that this rota quota system has been introduced, and if it keeps working properly, efficiently on a year-to-year basis, this problem is not going to arise. All this concern, and this is because this rota quota system is not being implemented. That's my first submission. Now, my lords, without prejudice to this submission, without prejudice to this rota quota and all, my lords may just come to another table which I have presented, my lord, WS1, page 57, another table. On the basis of the facts and figures, first I'll refer to position in Madhya Pradesh. 41 years is the age of entry of direct recruits in the district judge cadre, 41 years, average, page 57. WS1, it's a tabular chart, my lords.
Average.
Average 41 years in DJ cadre, direct recruit, 53 years in PDJ cadre, principal district judge cadre. Similarly, for promotees, it is 41 years as per the counter affidavit of the High Court, my lords. I have culled out that. 41 years in the DJ cadre for the promotees, the 25%, the 50%, and 55 years in the PDJ cadre, only 2 years gap. So, my lord, there is no prejudice as such, despite the fact that rota quota system has not been implemented. Now, my lords, I have given I'll not read all of them. I have given the figures of date of entry in Chhattisgarh, Jammu, Kashmir, Ladakh, Kerala, Punjab, Haryana on the basis of counter affidavits, the average age of entry, which has been evolved. Now, my lords, today, out of 52 district judges, the principal district judges, today, 52 or 51 principal district judges, 39, as per the counter affidavit, as on today, 39 are those who are from the promotee section, the civil judges. And only 12 are those who are from direct recruits. So, my lords, where is the ratio? The ratio rather goes in our favor. In fact, my submission is that the application should have been moved otherwise for addressing the concerns of the direct recruits, not for the civil judges, my lords. That's my submission. So, the ratio is 2.9:1, my lord, staggering almost 3 times of the promoters with the direct recruits. So, my lord, these were the facts and figures. Now, quickly, I have 2-3 submissions. I'll point out, my lords. There is
7 minutes or 2 more.
just yes, 3 more minutes.
Two more minutes.
Yes, please. My lords, one chart, my lords may just see in my written submission, that is volume 2, R4 would chart. I've just given a chart, my lords. After, my lords, now there are 2 dispensations. One is the pre-20th May dispensation and the other is post-20th May dispensation, my lords, which has arisen in view of my lord's judgment. I have given a chart, my lords, explaining the average time of progression of civil judge to entry into the district judge cadre, my lords. I'll not read that. And we have calculated it average on the basis of the counter affidavits, that if we take we consider merit, competency, diligence of the judicial officers, all the 4 channels now after 20th May, including the Rajneesh judge dispensation, my lords, 7 years. Within the age of 40 years, my lords, even after 2 attempts, within the age of 40 years, the civil judges would be entering the DJ cadre, my lords. Earlier it was 41, 43, 44. Now, admittedly, within 40 years. So,
Some lawyers have given a calculation that they would also enter at 35.
yes, my lords, 35. As if we see the Rajneesh judgment, my lords, we have calculated it at 37. I mean, taking 2 attempts into consideration, if not 1 attempt, then 2 attempts into consideration. My lords, my next submission is the cure to problem of stagnation of civil judges, which has given rise to this application, my lords. The cure cannot be worse than the disease itself. The cure, my lords, has been already suggested in one of the 3 judges judgment of this honorable court in the AIGA case I have given with my compilation 2024 volume 9 volume 5 R9 page 102. In short, my lords, what has been proposed by this honorable court, accepting the SNJPC recommendations, 3 judgment, my lords, that assured career progression must be given, model A, and second, there must be mechanism at the High Court level for compulsory writing of ACRs on an annual basis, reviewing, preparing, processing, and writing of the ACRs on an annual basis. If process of writing and finalization of ACRs is being done on an annual basis, my lord, as per the directions of this court. This stagnation is not going to arise because automatically the avenues of promotion will open up. My next submission, my lords, is that which is at page 28 of my written submission, that availability of uniform pay scale and equivalent promotional avenue for officers in the same cadre similarly situated is a guarantee protected by 14 read with 16(1) of the Constitution of India. Employees grouped in the same cadre, similar service condition, that is the district judge cadre, identical promotional avenues, common principal career progression shall apply, being a facet of equality in the matters of employment and state.
Yes, thank you.
Yes, Madam.
Thank you.
Well, just last submission.
No, you are already,
Well, 1 minute.
3 minutes, you are taken 5 more.
My lords, 1 minute. 1 minute. My lords, Triloki Nath Khosa has been relied upon, my lords. Triloki Nath Khosa, Vide paras 34 and 35, allowed, my lords, induction of graduation as a requirement, eligibility requirement for promotion on the ground. It was in consonance with Article 335, that is efficiency in public administration. The Supreme Court accepted it as a facet of promoting efficiency. Likewise, my lords, here, it is not a public administration, it is just providing a progression opportunity. My lord, there is one more judgment, Muhammad Sujat Ali, my lords. In Muhammad Sujat Ali, what was held was that it is not necessary that you must provide educational qualification for promotion. What has to be seen is whether your requirement for reservation or preferential quota aligns with the nature of duties or not. Eventually, the nature of duty has to be seen, the nature of public office has to be seen, Muhammad Sujat Ali. And therefore, my lords, my submission, last submission, my lords, is that the criteria that they must have a short progression avenue or promotional avenue, my lords, clearly doesn't fit in the requirement of 16(1) is my submission. Great. My written submissions are there, that they may be considered. There are 7-8 issues I have. Great.
Who is Mr. Muralidhar? Mr. Sai.
Lordship, I'm representing a single applicant in this matter.
Yes.
And by necessary implication, other 16 members of the same batch. In the present case, the RG Delhi, Jharkhand High Court has almost perjured himself by stating in an affidavit, considering that the provisional promotion that have been given shall be considered as promotions. Now, what has happened in Jharkhand is that despite 10:1 ratio on affidavit stated by RG Jharkhand High Court, they have already promoted by the notification dated 17th October this year itself, and provided selection time scale as well as super time scale. Thereby, anything that this court holds, unless given retrospective effect to, will have direct bearing on the process. Firstly, the law which is already prevailing is not being followed. Roster is not.
We are not addressing the individual grievances.
Your Lordship, this is not an individual.
You address on the issue frame.
Your Lordship, I didn't address a collective grievance. The process of screening of the problems, screening of the complaints that are given against judges, there's no mechanism of screening of the problems that are the complaints, the bogus complaints that are usually.
We are not considering the individual case of an individual judicial officer as to whether there are any complaints or not. We are just the issue has been framed by the court. Address us on the issue.
Your Lordship, that has a bearing on
Okay,
a person's.
Yes. Yes.
No, Lord, may I just make a small request, Your Lordship, may an indulgence, Your Lordship. I just want to.
My
I filed an IA.
submissions are on record. They may be
I filed
considered.
an IA, that's not come on record. I'm not addressing arguments. I'm just giving Your Lordship the statistics.
Use the mic, Mr. Mullah.
His Lordship?
Use the mic.
There was people here, so I didn't. Lord, I'm not addressing arguments. I'm just giving your lordship statistics in case a quota is implemented, how the seniority will be disturbed. So lordship, may just allow me to place that on record. While your lordship is writing the judgment, lordship may consider it. This is with respect to Haryana. May I just, if your lordship, may I just pass this on? I filed an IA. It's somehow not come on record. If your lordship could show me this indulgence, I'll just.
Yes.
Lordship, may just have para 21. I'll just point out one small para.
Not arguing, we are only
No,
talking
no,
about-
not at all, Lord. I'm totally satisfied with whatever everybody has said. I'm not going to trouble your lordship on
We'll look into your statistics, huh?
just the statistics, that's all. Because nobody placed them on record. It's just para 20, page 21, Lord. Lordship, just see what's going to happen. This is Haryana. This is A2, page 21. Lord, up to 2030, even if there's a 25% quota your lordship grants them, nothing will change. But after 2031, lordship may just have the last para of there'll be a dramatic change. May I just read the last, at the bottom, the last para? DR number 68 to 76 appointed in 2014 will be junior to promotees number so-and-so promoted in 2016. And then this will continue like this. I'm just pointing out these facts to your lordship. So there'll be a complete churning of the seniors will become juniors. This will continue. If your lordship could ask the High Court to verify it, I'm putting it on record on the basis of what I have seen.
You are appearing for whom?
I'm appearing for one of the additional district judges, the direct recruits. And also, Lord, in Haryana and in, over the last 10 years, only I think we have only about 6 direct recruits for the last 10 years.
The only last recruitment I had,
Yes, your lordship was
nobody has done.
nobody, there's been no recruitment. So this factor could also be taken into consideration. And then, your lordship, what happens is every recruitment is challenged again and again and again before this court.
11 years. Direct recruitment, last recruitment I had. The chairman of recruitment.
No recruitment, Pillar. That's the difficulty. I just wanted to bring all these facts before your lordship. It would help your lordship in making up your mind one way or the other, because there are serious problems otherwise. Now, this candidate, may I just point out, Lord, the vacancy came in 2004. 3 years, she had to wait for her appointment. And in case this happens, she will retire as an ADJ. She will not even reach anywhere near being a district judge. What to talk of coming to the High Court? That's a pipe dream for her. But
yes,
I've given this, Your Lordship. I just don't want to say.
May I just pass on one page of data, my lord, only, or arguments? Regarding that age, my lord, which I mentioned that the average age of the civil judge is 28 years. So large number of candidates are appearing who are of a higher age. So this discloses the data of the age, my lord, which the various candidates have appeared at different ages. So large number, almost 40 to 50% are my lords, above 30 years of age. That's one of the reasons, my lords, for age gaps. And it's a matter of choice, my lord, when a candidate appears, for sometimes people take chances of various other.
Yes, ma'am. My lord, would your lordship just have my written submissions, because I want to place a couple of paragraphs. My lord, your lordships may kindly come to page 23. So at page 23, my lord, at para 29, after setting out the various views, the various, my lord, situations where promoting judges are more or district direct recruit judges are more, this is, my lord, my submission in substance, in spirit for your lordships to consider. It's just one para I wanted to read. If your lordships has it, I'll just read. Sorry, my lord? Yes. The above shows, so above is the data that I put, shows that while in many states, mostly direct recruit district judges are occupying the post of principal district judge super time scale. In other states, the position is stated to be the reverse. Only in a very few states, the promoted district judges and direct recruit judges are occupying these senior posts in almost equal numbers. Therefore, it is submitted that it is imperative to strike a balance between the two situations, whereby while incentivizing the appointment of direct recruits from the bar, the extremely valuable judicial experience of in-service promotee judges is not lost, and both promotee judges and direct recruit judges are equally provided an opportunity to progress to the post of principal district judges and beyond. So this is the spirit in which, my lord, I have made my submission. Now, my lord, so your lordships have seen, in fact, even from what my learned friends on both sides have said, I am, of course, as an amicus, is that, my lord, there are different situations in different states, but there is a problem that needs to be addressed by your lordships, is my my lord, submission before your lordships. Your lordships may not take it that promotees deserve something here or the direct recruits deserve something in another state. It's not a state-specific problem, it's a national issue on which, my lord, I respectfully submit that your lordships will take a view to address the problem itself. I have given some suggestions. There can be any other suggestions which may be correct also, my lord. These are my suggestions for your lordship's consideration. Now, my lord, one of these suggestions that has come from the other side and which is a valuable suggestion, in fact, my lord Justice Suryakant put it to me on the very first day, is if the roster works perfectly fine year by year, etc., then a large amount of these issues can be sorted out, dealt with, etc. And the answer is yes, it can be. But, my lord, it will not fully deal. In fact, it will not deal with the age gap because the roster will not take into account the age gap. The roster will fully, my lord, perfectly. So far, unfortunately, the roster has not worked for 20 odd years, but let us assume for the sake of argument that Malik Mazhar is fully followed, roster is fully followed, every my lord, post is filled up annually, etc., perfectly filled up. The age issue will still not be gone into. And therefore, that is one of the points, one of the reasons which leads to bunching at the top. It is an important facet which, my lord, just by proper working of the roster should work properly, of course. And therefore, in some of my suggestions, my lord, if your lordships were to take that into account, that will require a bit of tweaking. That is my second submission before your lordships. The roster, my lord, will be working perfectly at the entry level, as I said, perfectly at the entry level. But, my lord, when it comes to financial upgradation, Shetty Commission uses the word financial upgradation. Promotion is a word that the rules mention, but it is actually in the nature of a financial upgradation to selection grade, super time scale, cadre being the same. That is where the bunching will happen because of age disparity. That is not the reason why I've given these suggestions for your lordship. Otherwise, my suggestion would also have been make the roster work properly and this sorts out the whole problem. So this is, my lord, my second suggestion.
That hardship which was being caused because of this age factor,
My lord.
that stands effectively addressed by the other constitutional bench. We took this.
Rajneesh, my lord?
The other constitutional bench judgment now.
My lord, that only deals with the issue of civil judges now being allowed to directly. Yes.
So they are able to now compete even for direct.
Correct.
Or if they are eligible for the 25% with enhancement of from 10% to 25%.
I'll answer that.
So they will have now accelerated promotional avenues.
Correct. So I'll straight away come to that issue because that's a very important point. What was said was, and it was also correctly said, that there are 3 avenues open. Firstly, my lord, from civil judge junior division to civil judge senior division, after 3 years, you have the option to take this limited competitive examination. So that gives you one opportunity to move upwards. Second opportunity to move upwards, my lords, is from civil judge junior division to district judge entry level by taking the limited competitive examination, which was there since 2002. And what my lords have just put to me is now there's a third way in which you can abandon the civil judge cadre altogether and join the direct recruit cadre. That's an option open to you. You know, the only difficulty with that, of course, it's open and people have their choices. Problem with that will be that there will still be 50% of the district judge cadre who will not be an LC, will not be part of LC. These are not dead wood people. These are people who've been promoted from step to step, passing suitability tests, etc., based on ACR and performance. So it is not as if these are people who don't deserve anything. So, Milord, these are highly deserving 50% people who may not have gone through or may not have cleared LCA examination or may have chosen not to take direct recruit examination, but that is 50% of the cadre today. So, Milord, that will always be the case. Whoever moves on to a higher, takes the LCA, etc., but still 50% will be these people. So that is a suggestion, not for lordship's consideration, that one has to, so balancing will require consideration of this 50% of the cadre also. Now, my lord, next, let's examine one more issue. Let's look at the question of, my lord, selection grade and super time scale. The rules say it is merit come seniority. So let's say merit. So, all right, my lord, so someone says, very well, it's merit, so the entire cadre comes into the picture, so there's no discrepancy, no discrimination also. Two levels of discrimination. Firstly, to be eligible for selection grade, you have to be 5 years as district judge entry level, which a person of higher age will be ill, will not in a position to afford that. Secondly, there is a zone of consideration. So if you are opening up the field to everyone is all right, but you are saying merit comes seniority, but zone of consideration 3:1. So if it is 3:1, then for one post only 3 officers, and normally the senior most will be seen. And your lordship saw the West Bengal rule which my learned friend Mr. Jaydeep Gupta cited. The criteria to enter into that zone is fairly minimal, if I may so. One, you should not get E or F, etc. That is not merit. That's mostly suitability for you to reach that level. Either your lordships are opening up the entire cadre for everyone to be considered on merit for selection grade and my lord, the super time scale. Otherwise, zone of consideration will again restrict everything back. Just have a look at one, my lord, rules that I cite. Most high courts follow that. Just see the Assam rules. Most high courts have this. It's the beginning of my written submission of the, which volume is this? 4A, page 81. Lord, please come to volume 4A.
Volume 4.
Volume 4A, my lord. I'm just citing one. Most of the high courts have the following, my lord, rules. These are the Assam Judicial Service rules. They start, my lord, at
Page 33.
33. But, my lord, I'm not troubling your lordship with that. Please come straight away to, my lord, page 80, Schedule E. 4A.
You are referring to page?
My lord, I was at page 80, Schedule E, which is titled, my lord, General Criteria for Promotion. And my lord, as I said, virtually all rules follow this pattern, maybe a little bit here and there, but the pattern is the same. So, my lord, the general criteria for promotion, if your lordship has it at page 80, is A. Considering the number of vacancies to be filled up, assessment committee shall assess the judgments ACRs of the officers who are within the zone of consideration, ratio being 1:3. Suitability and overall performance of officers, including disposal of cases, and the remarks of the concerned portfolio judge shall be considered. In case any departmental proceeding or inquiry is pending against an officer, his promotion may be considered and the decision be kept in a sealed cover to be opened on conclusion of the departmental proceeding. D. Officers against whom there is adverse entry regarding their character, integrity will be eligible for promotion provided the required benchmark has been obtained subsequent to the adverse entry. Now, my lord, if your lordship would just turn to the next page. And here, my lord, we are concerned with this subheading from district judge to selection grade district judge, which is, my lord, at the bottom of page 81. So there are 3 criteria. One is merit and suitability. Second, minimum 4 good out of last 5 ACRs, or officer must have 2 good and 1 very good ACRs in the last 5 years. And then, my lord, from selection grade district judge to super time scale district judge, merit comes suitability. Officer must have 3 good and 1 very good grading during last 5 years, or officer must have 2 good and 1 outstanding grading during last 5 years. So, my lord, first of all, there is a time period that for which you need these gradings. Secondly, although it says merit comes suitability, but you have restricted it to 1:3. So, my lord, in a sense, what you are giving, what is sought to be given is pure merit, is taken away with the zone of consideration, because only 3 officers per vacancy are being considered. So, where is the question of the merit across the cadre being considered? My lord, with great respect, my lord, the question I asked.
What's wrong with this criteria, Mr. Bhatnagar? How can within a cadre?
Yes.
Again, that most quoted expression. How can we create an artificial parity or disparity on the basis of birthmark?
No, we are not.
They are amalgamated in cadre at the entry point, and
Yes.
seniority point, whether based upon roster or continuous length, whatever may be.
My lord.
Once the seniority list is determined, then how can you further classify them?
I'm saying don't classify. I'm saying that don't reduce it to 1:3. By reducing it to 1:3, you are taking people out of the my lord, zone, is what I'm saying. Suppose, my lord, the criteria is merit.
Selection grade or super time skill can't be granted to the entire cadre.
No, it can't be.
So basically a financial incentive
Incentive.
on seniority,
Yes,
performance, both.
my lord.
That's why merit comes seniority.
Yes.
It's not something time scale that you.
It is not like the civil judge cadre where it is time scale. But, you know, what this does in effect is, this now excludes people who come in at an older age, and therefore either they retire earlier or they are lower down in the. So it adds to the exclusion of people, is what I'm saying. If it is pure merit, fine, no problem. That's one way of looking at it. But this is an exclusionary principle.
There is a rule which the interplay between the rule is like this, that it excludes a particular class of person, then understandable. But this is a simple incidence of service.
No, it is an incident. Merit comes seniority is an incident of service. But having said merit comes seniority, which effectively means merit, seniority only if merit is equal, then you make it 1:3. So the age factor, so a person who is older, etc., who comes in later or has later into the cadre or lower, doesn't come into the zone. That's the problem. That's my second submission, therefore, is only based on the zone of consideration. My second suggestion to your lordship. My lord, the third argument is, my lord, with respect to the argument, my lord, that was made about this being in the nature of a reservation and not being permitted. Mr. Bhushan had argued that point. For that, I only want to cite one para of one judgment before your lordship, which is, my lord, at page 43, page 40 of my written submissions. This is not a 5-judge bench, it's a 2-judge bench. But the question here, my lord, is exactly this.
Page 40 of your.
My lord, page 40 is a judgment of my submissions, my lord. There's a judgment called Kuldeep Kumar Gupta, which your lordships have.
Yes.
My lord, please turn over the page to 41. There is a question 2. Providing a quota in the promotional cadre, whether can be said to be reservation within the meaning of 16(4), and as such can it be held to be violative of 16(4) of the Constitution? And the answer which was given by your lordships is at page 43. Just one para I wanted to place. I commend, my lord, this view with great respect to your lordship. So far as the second, top of 43, so far as the second question is concerned, we are unable to persuade ourselves to agree with the submissions of Mr. Subramaniam that providing a quota tantamounts to reservation. Article 16 deals with equality of opportunity in matters of public employment, and 16(4) enables the state from making any provision for reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. This court in Indra Sahni's case has held that no such reservation is permissible in the promotional posts, and to get over the said decision, 16(4)(a) has been inserted by the Constitution. But we fail to understand as to how providing a quota for a specified category of personnel in the promotional posts can be held to be reservation within the ambit of 16(4). Providing a quota is not new in service jurisprudence, and whenever the feeder category itself consists of different category of persons, and when they are considered for promotion, the employer fixes a quota for each category so that the promotional cadre would be equibalanced, and at the same time, each category of persons in feeder category would get the opportunity of being considered for promotion. This is also, in a sense, the larger interest of administration, when it is the employer who is best suited to decide the percentage of posts in the promotional cadre, which can be earmarked for different category of persons. In other words, this provision actually effectuates the constitutional mandate engrafted in 16(1), as it would offer equality of opportunities in matters relating to employment, and it would not be the monopoly of a specified category of persons in the feeder category to get promotion. We therefore do not find any infraction of the constitutional provision engrafted in 16(4) while providing a quota in the promotional cadre, as in our view, it does not tantamount to reservation. In fact, my lord, in the 2002 judgment, your lordships have provided a 50% promotional quota to, my lord, judges from the civil judges junior division. That's also, my lord, there. That's what your lordships have already done, which everyone has accepted. You know, lastly, I'll come to the Trilokinath point, which was taken. Now, my lord, there, the proposition I'm placing before your lordships is this. When, my lord, two categories are integrated into one class, they cannot be differentiated on the ground of their birthmark being lost. But this is not a classification based on birthmark. This classification, I submit to your lordships, if your lordships accept it, would be in the nature of improving efficiency of administration. in the interest of improving judicial administration, which your lordships in KV Rajneesh, the 5-judge bench which my lord referred to, have said already that judicial experience far exceeds advocate's experience. So, my lord, in my respectful submission, this does not fall foul of the Trilokinath principle at all. Your lordships are not differentiating on the basis of birthmark. But this is
However, here the upgradation is on the basis of experience also. That's experience as judicial experience as a district judge.
Yes.
5 years. So in this situation, how do you add on the additional experience which is already merged into the common cadre?
because that experience only a civil judge, because the vast experience of 15, 20 years, 10 years, 15 years that they have is only limited, is only given to civil judges who come through that route. A district judge does not have that experience, a direct recruited district judge. So either we say that does not count at all. If it does not count at all, then of course the argument cannot be accepted.
Does it have a rational nexus when the role performed is one of a district judge, which is of a much superior judicial role than that of a civil judge junior?
Correct. But even while performing that superior judicial role, the fact that you performed a judicial role is not, in my respectful submission, written off, number one. Number two, what is also not written off is the fact, my lord, that the other person has come as an advocate or perhaps as a civil judge for a few years, but here he's continuously for 15, 20 years been a civil judge. Or, my lord, in the alternative, let's put it this way. Then, my lord, what the Justice Shetty Commission is saying is that give them some weightage for experience.
Another consideration.
That's another consideration.
Entry point.
At the entry point.
Does not fall foul of subclassification in a card.
I'm only giving your lordship the alternative to what I'm saying because I put that also as part of my submissions. That my lord is also there. The fact that 50% of the cadre, which is the promotional cadre, has that experience which Justice Shetty felt in 2002 to be given. Now, my lord, with great respect, the 2002 judgment of your lordships has rejected it, but there's no reason at all. My lord, there's one line in that judgment.
Relying on Sabarwa.
My lord, it only says one line. My lord, may I just show that line? Show me that 2002. My lord, I have with my written submissions set out in some detail the Justice Shetty Commission recommendations for your lordship's consideration.
That's your third suggestion.
The third submission, to which, my lord, the way the 2002 judgment has said, of course, your lordships are entitled to say that, but my lord, there's no reasoning given at all. It says only, just show me that paragraph. My lord, I'll just read that paragraph. My lord, in fact, this is it, paragraph at page 8 of my written submission is set out there. Para 30, my lord, at page 8, we disapprove the recommendation of giving any weightage to the members of the subordinate judicial service in their promotion to the higher judicial service in determining seniority vis-a-vis direct recruits and promotees. Roster system will ensure fair play to all while improving efficiency in the service. So that aspect has not been gone into, which I have again put before your lordships to please consider now, because this is an opportunity. In Rajneesh's case, for instance, your lordships accepted several of the Justice Shetty Commission's recommendations made in 1999. I'm requesting your lordships to look at this and see whether this could be something that can be gone into. Now, these are my 4 or 5 points. So.
Thank you.
Sir, आप इधर आ जाओ. But Mr. Devri wants to just add a little bit.
It's not, but this 5 minutes only, if not.
Says with regard to the first suggestion, as far as the Amicus's first suggestion is, he's put it as 1:1, but taking in account the fact that there are 3 categories, your lordships. The division in the roster, your lordships, has to be 75, 25, 25.
Then what is the incentive for the direct, if we provide 25 for them? Why would they give that service and come direct?
Your lordships, as far as LDCs are concerned.
For LCD also 25.
Your lordships, I'm talking about LDCs only. As far as LDCs are concerned, your lordships, our roster points cannot be clubbed with either promotees or the direct recruit. It has to be a separate roster point, your lordships.
How can there be a separate roster point?
It is already a separate roster point.
Rightly, first 2 will go to the promoters, the third will go to The LC and fourth will go to a direct.
Yes, your lordships, that's what I'm saying, that even in terms of weightage, etc., when that is calculated, your lordships, the same benefit should flow to all of us. That is what I'm saying, that as far as LCD is concerned, your lordships, it being a category cannot be deprived of the benefit which it is getting otherwise as well. That's
You are
what I'm
already
saying.
getting a jump over the others. So.
Your
this is
lordships,
the
in
right-
bunching, come down. The problem that we are facing on ground, your lordships, in bunching, we are coming down. That is the problem that we are facing, whereas because of the merit, your lordships, we must be placed higher. That is the ground reality that is happening.
Now, this is just 2 minutes I would like to say. The rest is, I will follow what my friends have said. Lord, my submission was to assist your lordships that the rota system, which has been borrowed from Sabharwal's case, fairly doesn't apply, in fact, because it's a case of one selection and this is the case of 3 selections. So unless we follow the roster system or the selection process as laid down in Malik Mazhar Sultan's case, it would not be possible to apply the roster system at all. So if Malik Mazhar is sought to be followed meticulously, then perhaps simultaneously appointments can be issued not following the roster system. But the problem that arises if we start applying roster system not annually, but like a current account. That should not be done. Otherwise, we'll be attributing seniority to the people who are appointed in 18, 17 or 16 seniority. That could not be. That is resulting in unfairness and bunching. That's my submission.
Specifically for the Madras High Court, Your Lordship.
Thank you.
Lordship, 30 seconds.
Grateful.